Ash Jam.
Right.
No, I thought he turns us on over at the control station.
Okay.
You ready?
Well, I don't know, maybe I turned mine off now.
Where you at today?
I just came back from the city.
Right on.
Saturday.
Okay.
I got a meeting tomorrow night. You got
Good evening, ladies and gentlemen. We're going to start the meeting now, so everybody please try to grab a seat. This is the Will County Board Planning and Zoning Commission meeting of May 12th. This meeting is a county special PZZ meeting, additional public hearing due to court order under this 26 CH-79, allowing plaintiff to cross-examine, to cross-examine and present evidence. So we're going to call this meeting to order. I ask everybody to rise for a pledge of allegiance. Lead us in a pledge, please. Allegiance to the flag and states and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Come tonight?
Well,
Roll call, please.
both ways.
Oh, yeah, I saw that.
Here.
Here.
So, Roger Bettenhausen, Karen Warwick. Here. Louis Navarette,
Here.
and Matt Garland.
Here.
5 present.
We have a quorum.
And there are no minutes to approve tonight.
What did she say?
No.
Yeah. Okay. Seeing as we have no minutes, we're going to start right into the zoning cases. So, this is Lincoln Solar Energy LLC. Property owner, details, owner of record, et cetera. Margie, would you care to?
Yeah,
Marguerite Kenny.
I can give a quick summary from the previous 2 meetings. The minutes have been approved last week at our Planning and Zoning Commission meeting, so they are available and have been added to the public record. This zoning request is that special use permit for a commercial solar energy facility. You have several variances, so 96 variances for the maximum ground cover plant height from 13 inches to 36 inches. 96 variances for the number of required mowings from 5 times to 1 time, and then 3 different variances for lot frontage to correct those 3 pins so that they are conforming A1 lots. If I can have next slide. Just a quick vote history. The Planning and Zoning Commission recommended approval with a vote of 6-0 for all the variance requests on March 31st at the previous meeting. Next slide. And then with the special use permit, the Planning and Zoning Commission recommended denial, ultimately voted 2-4 with the special use for a commercial solar energy facility with a recommendation of the 4 conditions. The Land Use and Development Committee heard this request and added 2 additional conditions. So tonight, what's before you, you could agree to add those conditions as part of the record once you hear the cross-examination and additional evidence. If you wish to reconsider any of the votes you had, you would make a motion to reconsider, and then with the consent agenda for the variances, if you wanted to bring any of those separate, we are prepared to show those slides and help you make those independent consent or variance requests. And then next slide is just the overall conceptual site plan of what they are proposing. Anything that's in the light blue, light green indicates floodplain. And then the site-specific conceptual site plans that were in the staff report actually go into detail, show the wetlands, the floodplains that they've done so far with the due diligence. But further due diligence would be occurring too as part of their building permit. And then last slide just shows all their submittal items for this zoning application. So I think now the development team's going to come forward if you wish.
I guess we'll start by swearing everybody in. All speakers who are speaking today, please raise your hand. I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. I do.
Start speaking.
And one more caution, everybody, please turn down your cell phone or put it on airplane mode. Thank you. You may start, sir.
Can you hear me? Oh, there we go.
Keep talking. He'll adjust them as we
It'll
talk.
adjust. Okay. Thank you, Mr. Chair. Good evening again, board. Happy to be back and members of the public. My name is, again, for the record, is Ben Jacoby, and I'm the attorney for the applicant here tonight. As staff just noted, we're here following the remand of this matter from the county board, which was at the direction of the circuit court. The purpose of this hearing is to allow Mr. Becker to conduct cross-examination and present evidence on behalf of his clients with respect to this special use permit that has been requested by the applicant. I do want to clarify that the variances are not at issue tonight. The variances were voted on and that vote stands. The only issue then on remand to this board is the special use permit for your consideration. Pursuant to the order of the court, Lincoln Solar, the applicant here, also supplemented the record on May 8th with a memorandum that you have before you. That memorandum is titled Subject Wilton, Manhattan, and Green Garden Townships, Will County, Illinois, Pride of the Prairie Solar Executive Summary Wetland Delineation Supplemental to Updated Site Plans Memorandum. And I'm going to explain what that means. But for the record, that's the memorandum that has been supplemented into the record by the applicant. That was done on May 8th. I'm going to briefly lay some foundation for this memorandum with Mr. Calbus and enter that document into the record. And then I'll tender Mr. Calbus over to Mr. Becker for cross-examination. I think Mr. Calbus, as the lead developer, will answer most of the questions that Mr. Becker poses, but to the extent we need additional subject matter experts, we have those witnesses available with us here tonight as well. The court order did set some guardrails, and some witnesses have been waived by Mr. Becker, but I don't expect we'll run into any issues with that tonight. But just for the board's awareness, there is some streamlining that, with agreement of council, we've tried to make here tonight. So with that, I want to conduct a brief direct examination of Mr. Calbus to lay the foundation for the memorandum that was entered into the record. And then again, I'll turn it over to Mr. Becker. Mr. Calbus, can you do a mic check for me?
Check.
I think the more you talk, the better it gets. Okay, so Mr. Calbus, I'm placing in front of you the document I just described titled Wilton, Manhattan, Green Garden Townships, Will County, Illinois, Pride of the Prairie Solar Executive Summary Wetland Delineation Supplemental to Updated Site Plans Memorandum. Do you recognize this document in front of you?
Yes, I do.
And was this prepared under your supervision as the lead developer of this project?
Yes, it was.
I want to take one step back. The latest iteration of the site plan for this project is dated March 5, 2026. Is that correct?
That's correct.
And you filed a site plan with the application, the original site plan, on November 19, 2025, correct?
Correct.
Can you briefly explain the difference between the March 5, 2026 site plan and the November 19, I'm sorry, strike that. Can you briefly explain the difference between the March 5, 2026 site plan and the November 19, 2025 site plan?
Yes, at the request of the Will County Land Use Department, we added 3 facts to our site plan. One of them being the approximate number of modules, the panel height, and panel spacing.
Thank you. So did the November 19, 2025 site plan, did that delineate the wetlands?
Yes, it did.
And how were the wetlands delineated for that site plan?
We utilized the National Wetland Inventory data set available from the U.S. Fish and Wildlife Services to satisfy the requirements of the ordinance.
The National Wetland Inventory, otherwise known as the NWI Desktop Review, is a data set, you said, compiled by the U.S. Fish and Wildlife Service?
Correct.
And that data set is, strike that, is that data set routinely relied on by professionals in your field to delineate wetlands?
Yes.
Is it your understanding that the delineation of all wetlands in the November 19, 2025 site plan, as identified by the U.S. Fish and Wildlife Service in its NWI data set, satisfies the county's ordinance requirement to show wetlands in your site plan?
Yes.
The November 2025 site plan has some field delineation as well, is that correct?
That's correct.
And how are field delineations generated?
We send environmental professionals to the site to walk the premises, and based on their training and observations, they determine if features that they measure the perimeter of meet the criteria for classification as a wetlands.
Are field delineations seasonal in nature,
Yes, they are.
meaning they can only occur in some seasons and not in others?
Yeah, they can only occur in certain seasons when certain vegetation is observable.
And they require landowner permission?
That's correct.
Has field delineation been ongoing since the November 2025 site plan was generated?
Yes, it has.
Was it your understanding that you needed all field delineations to comply with the county ordinance requirement for the site plan?
No, those field delineations are not required for the special use permit application. Those field delineations are being prepared in anticipation of the site development permit, the next step in the permitting process.
Okay, thank you. If the NWI data set from the U.S. Fish and Wildlife Service is reliable, then why do you do the field delineations?
Because they're required for that site development permit.
Okay. Since November 2025, has the team continued to conduct field delineations?
Yes,
Have you completed the field delineations since November 2025, the November 2025 site plan was generated?
yes, with our most recent mobilization in April, we have completed all delineation of wetlands on our site.
So you've now identified all wetlands in the project area?
Yes,
The memorandum before you that we just referenced and entered as an exhibit before you, that delineates those wetlands from the field delineation. Is that correct?
that's correct.
And this memorandum supplements the site plan dated November 19, 2025, and as updated on March 5, 2026. Is that correct?
Yes,
And the site plan attached to the memorandum is designed to overlay the most recent iteration, which is the March 5, 2026 site plan, correct?
yes, it is.
So now, just so we're clear in the record, there exists a site plan that delineates every single wetland in the project area as delineated by both U.S. Fish and Wildlife Service NWI data set and by your own field delineations.
Yes,
And just like all wetlands previously identified and testified to in March, you will avoid the permanent impacts to all wetlands identified in this supplement. Is that correct?
yes, we will.
Okay, thank you. Mr. Chair, with that, I believe the foundation has been laid for this exhibit, and we'll request that it be entered into evidence, and we will tender the witness to Mr. Becker.
First of all, I am Stephen Becker. I am the attorney representing the plaintiffs in this matter. And before I begin my cross-examination of Mr. Calbus, I just want to make an objection on the record to the introduction of this document, as well as to all of the testimony that was given. The order from Judge Breslin was simply for the plaintiffs to conduct cross-examination and to present evidence. There is nothing in the judge's order on the temporary restraining order allowing the applicant now to attempt to supplement the record with additional information that they did not present before. So I will be back in court on Thursday with Earthrise. I will raise this with the judge because we did discuss this at the court hearing, and it's my construction of what she said, that the applicant is not allowed to put in additional evidence at this point. So that's something I guess we'll have to take up to the court, but I just want the record to reflect that the plaintiffs object to this document as well as to any testimony given with respect to it because it is outside the court remand. So with that, I will begin cross-examination of Mr. Calbus. Mr. Calbus, is it correct that Lincoln Solar Energy LLC, the Earthrise, filed a single SUP application, ZC 25-129, that includes 96 separate property parcels encompassing approximately 6,099 acres, extending a solar facility project footprint across 3 different townships: Green Garden Township, Wilton Center Township, and Manhattan Township?
Yes,
And would it be correct to say that if passed by the Will County Board, your solar project would be the largest solar facility within the entire state of Illinois?
If you know, Mr. Calbus.
I don't know the answer to that. I don't suspect it would be.
Right? And why did Lincoln Solar Energy LLC choose this particular site for the solar project?
I'm sorry, could you repeat your question? I had trouble hearing.
Oh, sure. Why did Lincoln Solar Energy LLC choose this particular site?
We chose this particular site because of the ability to interconnect at our natural gas peaking plant in Manhattan.
And was it also because Will County's special use ordinance permits non-contiguous parcels to be included in a single SUP application?
That was not one of the factors that was taken into consideration.
Was one of the factors that was taken into consideration the fact that your proposed facility is near the massive Hillwood data center?
A massive, excuse me, what gas line?
Oh, I was asking, is one of the reasons that you chose this site because it is near the Hillwood data center in Joliet?
The data center.
No, it was not.
All right. And were there other available sites for you with less water resources that you could have chosen for this project?
Our primary consideration in selecting the site was the proximity to the natural gas peaking facility.
And is it correct that the cost for the Lincoln Solar Energy Earthrise project is estimated at around $1.2 billion?
We haven't made a final determination on the cost yet. That's still there's still factors being negotiated right now.
Could you give me then an estimate of what the cost is according to your knowledge?
I mean, it could vary substantially, so I really wouldn't feel comfortable giving an estimate at this point.
Can you estimate whether it would be over $1 billion?
It could be over or under $1 billion.
And would you agree that since Lincoln Solar has decided to pursue a single SUP application, which includes 96 non-contiguous property parcels, that if one or more of those parcels is deemed to be unsuitable, the entire application would fail?
I'm sorry, that calls for, are you asking legally under the ordinance whether that would be the determination? Or are you asking whether the project is viable with one or fewer, with one parcel fewer?
Yes, correct, the latter.
The latter. So would the project be viable if one parcel is deemed unsuitable?
Deemed unsuitable by whom?
Good question. I'm not sure we understand the scope of your question, Mr. Becker. Could you rephrase it?
Yes, I can. So let's say, for example, that one of the parcels is deemed to be unacceptable by the board. And let's say you have another 10 properties connected to that, since this is somewhat of a serpentine structure that you have for the project. Would that eliminate all of those adjoining properties if one is deemed unsuitable?
That sounds like a legal question that I'm really not qualified to answer.
And with respect to your community outreach, did Earthrise representatives attend any public meetings in Green Garden Township to answer questions and explain to local residents its proposed plans for the solar facility?
We did not attend any public meetings. We met with several representatives from the township.
And why did you choose not to have any public meetings in Green Garden Township?
One of the decisions, one of the reasons why was because of the hostility that we observed online from the township. We didn't think that a meeting would be a forum conducive to an open exchange of information.
And did Earthrise representatives attend any public meetings in Wilton Center to answer questions or explain to local residents its proposed plan for the solar facility?
We did not attend any meetings in Wilton Township. We did hold an open house meeting and invited members of Wilton Township, Green Garden Township, and Manhattan Township to ask questions and shared information with them.
And why did you not conduct a public meeting in Wilton Township?
The same reasons that I mentioned for Green Garden. We did not believe that it would be a conducive environment to open exchange of ideas.
Mr. Becker, when you say when you say attend a meeting, what do you mean by that?
Well, I was asking if you conducted a meeting in that particular township for the public to discuss your project with the residents and the local officials.
Other than the open house that was described? Okay.
We did host an open house in Manhattan Township, and members from of all townships were invited to attend.
Okay. So it was only in Manhattan Township then that you held a public information meeting?
The public information meeting that we hosted was in Manhattan Township, correct?
Right. And did you not hold the meeting in Wilton Township because of the perceived hostility of the residents as well?
No, that was based on the availability of a suitable facility.
Next, I'm going to refer to what we have marked as exhibit number 1 in the packet that we provided to you. And Mr. Calabus, have you seen this document before?
Are you referring to the development agreement?
Yes, that's correct.
Yes,
All right. And is this a Earthrise development agreement?
it appears to be an Earthrise development agreement.
All right. And does this appear to be a true and correct copy of the document used by Earthrise?
Based on just my cursory analysis, yes.
And on page 1 of that particular document, does it state up in the right-hand corner that the document is confidential?
Yes, that's correct.
And referring now to clause number 14 on the second page, does this address the subject of confidentiality?
Yes,
And is this what we would normally refer to as a non-disclosure agreement?
I'm sorry, that's a legal conclusion, counsel.
I was just asking him generally if he knows what this clause pertains to.
Well, I think the clause speaks for itself.
All right.
Excuse me, Mr. Becker, were
Yeah.
we given any of these papers that you're referring to?
Yes.
We were.
Yes.
Okay. I haven't found it
I
yet.
don't have them either. Memorandum.
You have?
Yeah, I've got it.
Yeah.
That is theirs.
Yeah.
Okay, I'm sorry. I just
Yeah.
would like to follow along.
Have them either.
Yeah, most of these documents were going for the witnesses. We just provided several copies in case you had any questions later on.
I copy, but.
So this particular clause, why did you impose this particular non-disclosure clause on the owners in these agreements?
Hold on, Mr. Cavas. So the document that we're looking at right now marked as Exhibit 1 is an unexecuted document addressed to the Donna J. Robinson Trust dated January 8th, 2010. So there's no executed document that's
Give them to us tonight.
being inquired on. So I think the question needs to be rephrased.
The question is in clause 14 in your development agreement. This is a sample, so I assume that all of the agreements are similar language. Is that correct?
They are substantially consistent, but some of them do have bespoke terms.
Right. Then why do you basically impose a gag order on the owner when you enter into these types of agreements?
I don't know if it's a gag order. I think it's a confidentiality clause that you're referring to, but the witness can ask the question with that in mind.
Well, I would like Mr. Calaboose to please answer the questions rather than the attorney.
Well,
If you don't
counsel,
mind.
counsel, that's fine. Mr. Calvis will answer the questions, but when you phrase it as a non-disclosure agreement or a gag order, you're putting words into his mouth. So the provision number 14 is titled confidentiality. There's some terms. If you'd like to ask him about the scope of that term, then I'm sure Mr. Calvis would be happy to answer.
Yeah, so why do you prevent the owners from disclosing any information about your agreement?
Well, developing power generation infrastructure is a competitive business, and we view the terms of our agreement as a competitive advantage. And so we intend to protect those terms.
So why can't the owner disclose that they have an agreement with you?
I, the owner is not agreeing to not disclose that they have an agreement with us. They're agreeing not to disclose the terms of the agreement.
So they could still tell anyone that they had an agreement with you, is that correct?
I'm going to object. Are you calling for a legal conclusion from this agreement?
No, I'm just asking for a basic factual answer, please.
It sounds like you're asking him to interpret the document.
If he's unable to answer questions, then I'd ask you, please provide someone else who can.
If you're asking for a legal conclusion, then you'll have to ask that in a lawyer. But if you're asking for a factual answer on what the document says, then that is something we can answer.
Yes, and I just asked him a simple question of whether the owner would be precluded from revealing that they have an agreement with Earthrise.
And I think he answered that question.
I didn't hear an answer. He could please
Okay.
repeat his answer?
Yeah, the owner is not forbidden from disclosing that they have an agreement with Earthrise. They're forbidden from disclosing the terms of the agreement and other proprietary information about how the site is developed, but not that they have an agreement with Earthrise, as you stated.
And how does this type of agreement and this clause square with Earthrise's ability to be transparent?
We don't think that protecting trade secrets is at odds with with those statements at all.
All right, next I would like to refer to what has been marked as exhibit number 2. And this is a solar lease and easement agreement. And this is in pertinent part. Have you seen this document before?
Yes, I have.
All right. And is this Earthrise solar lease and easement agreement, that's what it is in pertinent part? Is that correct?
It appears to be, yes.
All right. And does this appear to be a true and correct copy of the document generally used by Earthrise in pertinent part?
Based on my cursory analysis sitting at the table this evening, it does.
All right. And turning your attention to pages 4 and 5 of exhibit number 2, specifically clause 1.1C, does the lease define the project on the top of page 5 to include battery technology facilities?
Yes, that's stated in the agreement.
So is it correct that at any time in the future, you could seek to have battery storage units placed on any of the properties that you have secured via such a lease?
We would have to return to the county and seek permission to do so.
But based on this agreement, you would have a right to pursue battery facilities. Is that correct?
When we begin a project and we begin securing site control, We like to reserve our options. And so, yes, we do include that. And as the project firms up, as plans firm up, and we begin to rule things out. And so we do not have any plans to develop a battery facility today.
But you could in the future,
We
correct?
could in the future, but we would have to return to the county to permit it.
All right. And isn't it correct that battery storage facilities pose a huge public safety risk, especially around residential homes and subdivisions?
I don't believe so, no.
And why didn't you highlight this aspect of your lease and lease agreement in your application to the county?
Can you say, I didn't hear the question.
Can you
Mr.
repeat
Beck.
the question?
Sure, I sure can. So why did you not highlight this aspect of your lease and easement agreements in your application submitted to the county?
Because we're not permitting a battery energy storage facility.
And now I'd like to turn your attention to Earthrise's project narrative, which is attached as Exhibit 3 in our exhibit list. And this was also attached as Exhibit B to the Will County PZC final staff report. And I would ask if you could look at page 20 under the title of project description. And my question is it described as the solar project being a design concept?
Yes, there is.
Right, and turning your attention to the March 23rd, 2026 Will County final staff report, which is exhibit number 4 in your packet. Throughout the report, land use staff referred to Earthrise project as a conceptual site plan. For example, on page 5, the final staff report stated, quote, based on the concept site plan, an estimated 16,921 panels, that is 1,190,868 modules, will be located on the requested special use area, which is 6,099 acres. The attached site plan shows the proposed panel layout across the project. And again, on page 5, the staff report notes, quote, per the conceptual site plan and GIS aerials, the entire area is vastly agricultural farmland, wooded areas, and residential sites. My question is the plan Earthrise submitted for review to Will County seeking an SUP application a conceptual site plan, or is it a final site plan?
It's a conceptual site plan.
So is it correct that when the county board votes on your application, it will actually have no idea what the final site plan will actually look like?
I don't agree with that statement, no.
Well, if this is just a conceptual site plan, how can the county board vote on it if it could be changed later?
Well, ultimately, the land use department will have to determine if our final site plan substantially complies with the special use, the site plan contemplated in our special use permit application.
All right, next I'd like to refer you again to exhibit number 4, which is the final staff report. And there the staff listed a LISA score. Is it correct that the USDA's Soil Conservation Services acronym LISA stands for Land Evaluation and Site Assessment?
That's my understanding.
Right. Regarding the LISA score for the Earthrise project, the Will County final staff report on page 8 stated, quote, per the Natural Resource Information Report, a LISA score was calculated 236, placing the project footprint in the essential farmland category. The Will South Cook Soil and Water Conservation District recommends preserving essential farmland for parcels with a LISA score of 185 or above. A copy of the report is attached. Is it correct that the overall LISA score for the farmland encompassed in the footprint of the Earthrise solar project is more than 50 points above the LISA score that the Will South Cook Soil and Water Conservation recommends for preservation of essential farmland?
Based on the report that I'm reading here, yes, it appears to be.
All right. Would you agree that the Will South Cook Soil and Water Conservation District made a finding that based on the high LISA score of 236, the farmland being considered for this project is essential farmland that should be preserved and should not be converted into another use?
Yes.
Why then are you seeking to have your project placed on this prime farmland?
Well, as I mentioned, our site selection was preliminarily informed or essentially informed by proximity to the natural gas peaking plant.
Would you agree that Illinois farmland is some of the best farmland in the world?
I'm not a farmer, so I'm really not qualified to make that statement.
The March 23rd, 2026 Will County Final Staff Report stated on page 8 the following, quote, while the Illinois Department of Agriculture follows the Federal Farmland Preservation Act's LISA score greater than 225, it should be preserved as farmland. This project does not appear to be utilizing federal funds and would not be subject to complying with this requirement. However, during earlier presentation at the March 30th, 2026 PZC hearing, Mr. Jacoby indicated that the Earthrise project faced a time constraint related to when the building of the project needed to be started. If you are aware of what specific time constraints for the building of the project are incumbent upon Earthrise?
We're not, the start of the project is not under any time constraint. I'm not familiar with the statement Mr. Jacoby made.
In 2025, the Trump administration substantially altered the requirements for federal funds for solar rebates and tax credits for solar facilities from former President Joe Biden's Inflation Reduction Act when solar companies build new facilities. Under the Trump administration, in order to be eligible to receive federal Inflation Reduction Act funds, a solar project must be started by July 4th, 2026, and the project must be completed by the end of 2027. While solar projects started prior to July 4th, 2026 must be completed within 4 years. Is it correct that in your project narrative, which is Exhibit 3, page 25, Earthrise stated, quote, construction of Pride of the Prairie Solar is expected to last for 18 to 20 months, starting in the summer of 2026, with an in-service date projected in the first quarter of 2028.
That statement is accurate that you quoted. However, I think there's a typo in there and we actually meant 18 to 24 months.
Okay, thank you for that clarification. Is Lincoln Solar Earthrise going to apply for federal fund rebates and tax incentives from the Inflation Reduction Act under the new eligibility requirement timelines defined by the Trump administration?
We'll make that determination at an appropriate time.
So you may be seeking federal incentives, is that correct?
It's possible, yes.
All right.
But
if-
I'm sorry, but those aren't the same as federal funds.
I'm sorry. Okay, thank you for the
Can you
clarification.
please clarify, Mr. Calvis?
Yes. Yes, we will make a determination on seeking tax credits at an appropriate time.
If so, and you do seek those funds, how much do you expect to receive in these tax incentives?
I'm not a tax expert, so I'm not qualified to answer that question.
All right. The LISA score for these 96 Earthrise solar property parcels was 236. Is it correct that since Lincoln Energy will be seeking these tax incentives, that the project will be subject to the Illinois Department of Agriculture's rules for preserving essential farmland on the project with a LISA score of greater than 225?
I'm not familiar with that policy and I'm really not aware.
That's calling for a legal
Yeah.
conclusion, but Mr. Calvis, I believe the answer is no.
I'm turning your attention now back to Earthrise's project narrative, which is exhibit number 3 on page 32. Is it correct that as early as 2022, you conducted an outreach and were in contact with Will County about this particular solar project?
That was before my tenure at Earthrise, and so I can't confirm or deny that.
But is it correct that your project narrative, in fact, indicates that?
I would agree with that statement.
Are you aware of who Earthrise reached out to in Will County in 2022 regarding your project?
I'm not.
And are you aware in 2022 whether Lincoln Solar or Earthrise lobbied Will County officials to change its special use application ordinance to allow non-contiguous properties in a single special use application for solar projects?
I'm not aware.
And Mr. Calbus, are you aware whether Lincoln Solar Energy Earthrise is the first solar company coming before the Will County Board under the new 2023 Will County ordinance change allowing non-contiguous properties in a single special use application submittal?
If you know.
I don't know the answer to that.
Right. The next, I would like to turn your attention to exhibit number 5, please. And this was also Appendix L, C-313 at page 31, attached to your application. I would like to focus your attention on 2 properties just north of the Prairie Schooner subdivision. This is my client, Donna Robinson's property. This is parcel 545, which shows a black dot, which is her water well and the Earthrise solar property. Parcel 546, just north of Ms. Robinson's property. Can you explain why Earthrise chose a property that is bisected or cut in half by both Prairie Creek and a huge connected floodplain, thereby eliminating solar panel installation on half of this property?
And just before you answer, I just want to clarify for the record, we are looking at the March 5, 2026 iteration of the site plan. And Mr. Becker, you said parcel 546?
545 and 546, yes. I'm sorry, 544 and 546.
2nd here.
Yeah.
So,
Yes, the parcel right above 545 there.
Okay, right above 545, I see 542. Is that the parcel you're referring to?
Yes, that's correct.
And can you repeat your question? I'm not sure I followed.
Yes,
what you're
sure.
saying.
My question is, can you explain why Earthrise chose a particular property that is bisected or cut in half by both Prairie Creek and a huge connected floodplain, thereby eliminating solar panel installation on half of the property?
This parcel is suitable for development. So as you can see that there is a substantial amount of generation sited on this.
And after rain events on Ms. Robinson's property, this particular line is often flooded from the Prairie Schooner subdivision yards. Since there is both a swale and a listed stream coming south toward Ms. Robertson's property and towards Prairie Schooner, why did Earthrise engineers place a series of solar panels between these 2 bodies of water where her north property line is regularly flooded?
You know, when we develop a site plan for submittal with our permit application, it's usually a max build scenario because we know that we're going to continue to study the site. And in fact, this particular parcel, I can tell you that we have continued to study the site. And we are ultimately in the most recent iterations of our site plan, we do not have panels south of that flood zone.
So is it correct then, based on that, Mr. Calabus, that what was originally submitted to the county application is no longer accurate?
It doesn't mean that what's been submitted is no longer accurate. It simply means that we have refined our understanding of the site since then. And ultimately, that will be evaluated during the site development permit application review.
Now, turning your attention now to exhibit number 5, which is Appendix L at C-306, and this is page 24. I would like to focus your attention on 3 properties, 2 of my client's properties, client Jim Mickelwitz, number 193, and client Russell Wilkie, number 194, as well as the Earthrise parcel number 207, which is just north of my client's properties. Again, since Earthrise's parcel 207 is bisected by a large FEMA floodplain and has water swales, why would Earthrise choose this particular property to put solar panels on?
You know, as I mentioned before, we believe that this parcel is suitable for development. And when we submit a permit application, it's a max build scenario. So we're reserving the right. Again, we've continued to study this, and in our most recent iterations, a significant portion of those panels are not present in the site plan. For example, west of that flood zone, there are no panels, and a substantial portion east of it have been removed in our most recent iteration of our layout.
All right, now I'd like to turn your attention again to Exhibit 5. This time it was Appendix L at C-302, and this is going to be page 20. And I'd like to refer you to parcel number 57, which is owned by the Heidrichs. And these are dog breeders who show at the Westminster Dog Show and have sold to celebrities such as Oprah Winfrey and other celebrities. After realizing their 10-acre property and kennels were to be completely surrounded by Earthrise, they approached Earthrise's director of development, which I believe was you, Mr. Calaboose, to see if you would buy their property. And you apparently told her you were not interested. Is that correct?
That's correct.
Can you explain why Earthrise parcel number 58, which is just north of the Heidrich property, was chosen for the project, since it has a stream or a creek running straight through the middle of the property and has a floodplain?
Well, significant portion of that parcel is suitable for development.
And taking a look now at the Heidrichs property, which is parcel number 57, their home and dog kennels would be entirely surrounded by the panels to the north, south, east, and west sides of their 10-acre property. Does Lincoln Solar consider this to be acceptable business practice to completely surround a residential home?
When I met with Ms. Heidrich, I showed her the most recent iterations of our application, which showed that panels are the closest area, I think, close to 450 feet to the south. And that, you know, in the others, I think we're looking at 750 feet to the northeast and over 1,000 to the west. And so, as I mentioned before, when we submit a layout as part of our permit application, it's a max build scenario. But as we can study the area, we make a determination, you know, our layouts generally shrink, as it has in this case. And I've shared those designs with Ms. Heidrich.
All right, now again, refer you to Exhibit 5 again. This will just be one last property, which is one of our plaintiffs, and this is at C-308. It is page 26, and I'm referring to parcel number 393 and Earthrise parcels 387 and 389. Again, since Earthrise parcels 387 and 389 are bisected by a stream and or creek and a large floodplain, I ask again why this particular property was chosen for the solar project.
A substantial portion of that property is suitable for development.
All right. And my clients, Jim and Melanie Burke's horse farm is parcel 393. As you can see from the map, and the Burke's 5-acre horse farm is surrounded by solar panels on 3 sides, the east, west, and the south. Again, does Lincoln Solar Energy consider this to be an acceptable business practice to surround a home and horse farm on all 3 sides of the farm?
We base our siding and panels based on requirements, and will adhere to all requirements set forth under the Will County Solar Ordinance.
And turning your attention to Exhibit 5 again at C-307, an earthrise property parcel which includes 5 different and distinct wetlands on a single earthrise parcel is present. Can you explain why Lincoln Solar would choose this particular parcel as suitable for its solar facility when there are at least 5 different wetlands on the particular property?
Sorry, Mr. Becker, which parcel?
It's at C-307.
Yep. Which parcel?
Yeah, the number.
It is to the middle left on that particular page between LaGrange and Bruns Road. At the difficulty of the copy is very dull.
I don't.
The northwest, southwest, which quadrant? Oh, okay.
Here.
This is not, it's not the same page. Sorry.
It's just a little clearer.
Nope.
Can you read that number?
You said 522, or sorry, 229.
So put it out.
Follow.
Okay.
Knowing the area.
So for the record,
You have this map.
yeah,
You can't do
229.
that.
So we're looking at page C-307 and parcel 229, Mr. Becker.
Yes, that's correct. So my question was, since this parcel contains at least 5 different wetlands, why was this chosen for the construction of solar panels?
A substantial portion of that parcel is suitable for development.
And will these particular solar panel areas be fenced off?
Yes.
And how will then any wildlife be able to access the particular wetland areas?
Generally speaking, our fences will have a gap in the bottom of the fence that will allow wildlife to move in and out of the project area.
And would that allow deer to enter those particular areas?
No.
Okay.
Well, let me amend that and say it'll substantially deter. I can't really speak for what the deer will ultimately decide to do.
So the buck stops with them, is that what you're saying?
Oh, yeah.
Sorry about that. In the October 17th, 2025 EcoCat IDNR report, and this is number 2606552, which is attached as Exhibit 6 in our packet. Under its natural resource review results, it states, quote, "The following protected resources may be in the vicinity of the project location." And it lists on number 4 that one of those particular species is the short-haired owl. Is that correct?
That's what the report states.
And isn't it correct that according to the IDNR, if an applicant becomes aware of the presence of an endangered species which is encountered during the project's implementation, that the applicant must inform the agency and comply with applicable statutes and regulations?
Yes.
At the March 30th, 2026 PZC hearing, during the public comment period, several residents noted that an endangered short-haired owl with a broken wing had been found in a Manhattan farm field, then rescued and brought to a rehabilitation facility for eventual release back into the former habitat. Since the habitat of this endangered short-haired owl includes farm fields, have you contacted the IDNR to make them aware of the existence of the short-haired owl and made any further plans or submissions to the county with respect to that?
We've consulted with IDNR about our project area.
But my question was, once you learned of the existence of a endangered species within your project area, did you contact IDNR after that?
I think
I'm sorry, I couldn't hear your answer.
Yeah, we don't have to inform IDNR until construction has actually been begun on the project.
And I think we're actually talking about a short-eared owl, not a short-haired owl.
Yes, the short-eared owl. Yes, that's what I said. I'm now referring you to exhibit number 7, which is a screenshot of a Facebook page of the Flint Creek Rehabilitation Center, which evidences a photograph of an endangered species in Illinois, a female short-haired owl, which was rescued from a farm field in Manhattan with a broken wing. And if such an endangered species is living in Manhattan, would this preclude you from constructing any solar panels in that area?
Can you clarify your question? Are you implying that this owl was discovered in our project area or just within the village of Manhattan?
It was in the Manhattan area is the information from the Facebook page from the Rehabilitation Center.
And
So my question was, if there is a short-eared owl in the Manhattan area, which is part of your project area, would you be precluded from building your solar panels there?
I do want to be clear. If the question is the company precluded from building solar panels in a project area if the owl were found in the project area? Is that the question?
Yes,
I don't think-
that's correct.
Okay, because I don't think we've established the fact that this owl was in the project area. I think we've established that it's in the Manhattan Township area.
That's correct, but
Okay,
that's right.
okay.
So,
But hypothetically speaking, if an owl were found in the project area, what the protocol would be at that point? Is that the question?
yes, so would you have to
Okay.
go back, for example, to IDNR and find out what they would allow you to do in that particular region?
Our first step would be to consult with IDNR.
And isn't the identification of endangered species one of the requirements for compliance under the solar statute?
Say that again.
Yes. Isn't the identification of endangered species one of the requirements for compliance under the solar statute?
I think the solar statute requires an EcoCat consultation. Is that the question?
Yes, I'm asking if the identification of an endangered species is one of the requirements under the solar statute.
I'm
Hold
not
on.
clear what you mean by identification of the species. Can you clarify what you're asking?
Yes, if you have the presence of an endangered species within your project area, you have to identify that to IDNR as part of compliance with the solar statute.
Hold on. Can you identify where in the solar ordinance that provision is?
I was just asking you if that is in fact a requirement.
Can you identify where in the ordinance that requirement is?
No, I'm asking you, I'm not telling you what it is.
Well, I think the ordinance,
Isn't it required to have an EcoCat in order to get your solar application deemed complete?
so what the solar ordinance says, and this, by the way, is section 155-9.245 Q 1 I is that applications must include the results and recommendations from consultation with the Illinois Department of Natural Resources obtained through the Ecological Compliance Assessment Tool, EcoCat, or a comparable successor tool. Is that what you're asking?
Yes, that's what I'm asking.
Okay, then that's the answer.
And with respect to the EcoCat, under the disclaimer on page 2, it states the Illinois Natural Heritage Database cannot provide a conclusive statement on the presence or absence or condition of natural resources. If additional protected resources are encountered during the project's implementation, compliance with applicable statutes and regulation is required. So isn't it correct that if you become aware of the presence of an endangered species in your project area, that you are required to make another submittal to IDNR?
Another submittal?
Yes.
I think we can explain what the protocol would be if an endangered species were discovered in the project area. Is that the
Yes,
question?
if you could please explain what the
Okay.
protocol is.
Okay, Mr. Calvis, if an endangered species is discovered in the project area, what is the protocol?
To contact IDNR.
And did you contact IDNR after you learned from the last PZC meeting that there was the presence of an endangered species in the Manhattan area?
And again, the fact that is not in evidence is that that endangered species was discovered in the project area. I think we've agreed that there is no fact in evidence that the species was discovered in the project area, but that it was discovered in the Manhattan Township area. Is that, okay?
That is correct,
We're in
but your
agreement there.
project is included in the Manhattan Township area, correct?
Well, the project is in the Manhattan Township area, correct, but the project area is not entirely the Manhattan Township area. So there's not a 100% overlap. So I think if the question is, if an owl, hypothetically, if an endangered species owl is found in the project area, what is the protocol? The answer has been, we contact IDNR. If an endangered species is found outside the project area, but within Manhattan Township, then that protocol is not the same.
All right, I'll ask a simpler question. Do birds fly?
Yes, some birds do.
Thank you.
Are we still talking about the owl?
Yes.
Okay.
Now I'm going to move on to another area. Did you ever reach out to any of the local adjoining landowners who surround the 96 Earthrise property parcel footprint to discuss individual pre-existing flooding issues that they were having prior to submitting your application?
Our outreach to some of the adjoining or neighboring landowners was to discuss drain tile. In particular, that's one of the reasons that we reached out to the adjoining neighbors.
And did you ever go speak with Green Garden or Wilton Township or Manhattan Township officials to discuss existing stream, floodplain, or flooding or wetland issues prior to submitting your application?
I mean, those subjects have come up in conversations that we had with officials from those townships.
And did those discussions come prior to you filing your application or afterwards?
Some of them did.
Some of them did which way?
Some of them did occur prior to submitting the application.
All right. And would you agree that the 6,099 acre, 96 parcel solar project is filled with extensive water resources, including perennial, intermittent, ephemeral streams, large floodplains, and delineated and farm wetlands?
I would agree. I would say that some of those features are present in the project area.
Okay. And would you agree that the Earthrise Pride of the Prairie project is located in or near headwaters of Forked Creek, Prairie Creek, and Hickory Creek?
Yes, I would agree.
And are you aware that Fork Creek, Prairie Creek, and Hickory Creek and portions of those creeks are considered waters of the U.S. under the Clean Water Act?
I'm not aware of that. No.
All right. And how many different creeks or streams are located within the footprint of the 6,099 acre solar project?
I can't answer that question without referring to our application package. I'd have to count them up.
All right. And what is the definition of a perennial stream?
A perennial stream?
Yes.
I don't have a good definition to give you tonight.
Okay. How many of the 96 Earthrise parcels contain perennial streams?
I can't answer that question right now off the top of my head.
Right. And what is the definition of an intermittent stream?
Are you referring to a statutory definition? Or what is the definition that you're calling for?
Yeah, well, it's listed on all of your maps. So I'm asking what the definition is of an intermittent stream.
Oh, from the site plan.
Correct.
Okay.
Intermittent stream, I would, I think, describe as a stream that sometimes has discernible water flow in it and sometimes doesn't.
Okay, and how many of the Earthrise 96 parcels contain intermittent streams?
I can't answer that question off the top of my head.
And what is the definition of an ephemeral stream?
I would,
I'm sorry, Council, where's this on the site plan?
It's in the little code that's on the side of the maps, in the legend area. So there's a legend that has various colors indicating what they are on the maps.
I do see that. I see streams.
Yeah.
I'm looking for perennial streams and intermittent streams. I'm not seeing that, but I
Okay.
could be missing it.
All right, it's listed in Appendix L to your application.
Okay. Can you give me a page reference?
I can't right offhand. It's all throughout the appendix.
I mean, for example, I'm looking at page, Rob, am I missing this? I'm looking at page C302. And streams. I do not see those terms identified on, for example, page C302, which I've,
Well, we'll just move on then if you don't know what the definition is. What is the definition of a floodplain?
excuse me?
Pardon?
Can you repeat the definition of what?
Oh, yes, a floodplain.
A floodplain is in my basic understanding is a floodway. Floodplain is an area where flooding, area that is prone to flooding.
And how many of the 96 earthrise parcels contain floodplains?
I can't give you a count of that. I'd refer you to the site plan.
All right. Is it correct that according to the Illinois Department of Natural Resources, that 90% of Illinois wetlands have been destroyed and lost due to development, leaving only 10% of wetlands remaining in Illinois?
I'm not aware of any of that statistic, no.
Right.
So,
Why are wetlands so important to the environment and to surrounding landowners?
I'm going to object on the foundation. If you know, Rob, go ahead and answer.
I mean, you're asking me to speculate about something that's really not, in my understanding, pertinent to the application.
Do you list wetlands on your application maps?
We do.
And that's not important, you think?
Not what he said, Council.
That's not what I said. Yeah.
And what did you say again?
What was the question?
My question was, why are wetlands important to the environment?
When you say important, can you explain what you mean by important? I mean, that's a pretty broad statement.
Sure, I'll be happy to clarify that. Are you aware of how many gallons of water a 1 acre wetland holds?
I'm not. It would really depend on the depth of the wetland.
Would you be surprised to learn that they hold up to 1 to 1.5 million gallons of floodwater?
Which wetland are we referring to?
All wetland.
I'm at together, summed up.
Yeah, a 1 acre wetland?
Okay, 1 acre wetland. I'm just having a hard time following the foundation for the question. I'm not sure what you're asking.
I'll move on.
Okay.
What criteria need to be present to indicate the presence of a wetland?
There are 3 factors, and so that depends on soil characteristics, vegetation, and hydrology.
All right. And of the 6,099 acre earthrise parcels, how many acres contain hydric soil?
I don't have that exact number off the top of my head, but I believe that number based on the EcoCat is over 2,000 acres.
All right, I can clarify that for you further. Turning your attention to the Will South Cook Soil and Water Report, which is NRI 5824, which is Exhibit 8 in the packet on page 166. Yes, the last page of the exhibit. On page 166, it states under the heading hydric soils, quote, hydric soils present on site, approximately 2,152.3 acres of the 6,000, 46.4 acres of soils on the site are hydric. Is that correct?
The statement is accurate, or this is, you are accurately stating the statement in this report.
All right, so is it correct then, based on that report, that over 1/3 of all of the acreage being proposed for your solar facility contains hydric soils?
That's what the report says.
All right. And how many inventoried wetlands did you identify in the 96 earthrise parcels?
In the 96 earthrise parcels, I, based on I cannot give you an exact number of that this evening.
Do you think it's over 100?
Yes.
Okay. And how did you identify the delineated wetlands located on the parcel maps?
As
Are
I,
we referring to the delineated wetlands on the site plan attached to the exhibit or attached to the application? Because
Yeah, Appendix L, correct.
as you know, we supplemented the site plan with
Right.
the wetland delineation report. So, and there is a distinction between how the wetlands were delineated between those two. So I just want to make sure we're talking about the same
Yes,
document.
we are talking about Appendix L, the original report that we had.
Okay, so Exhibit L as of March 5, 2026?
Correct.
Okay. So the site
so
plan,
based on that, there were 99 delineated wetlands in it,
All right.
based on that version of it.
And my question was, how did you identify those delineated wetlands as of the March 5th?
Yeah, we sent environmental professionals out to the site who are qualified in identifying wetlands. They walked the site. They delineated the perimeter of features that appear to be wetlands, and then they measured, made measurements of and observations of to determine if they met the 3 criteria.
All right. And did this list of delineated wetlands, did you?
Well, let me clarify that statement. Can you repeat that question one more time? I
Sure.
apologize, having trouble hearing.
Sure. How did you identify the delineated wetlands located on the parcels?
And based on the March 5th, 2026. So
Correct.
the National Wetland Inventory provided the delineation of wetlands for that version of the site plan.
Right.
With some supplementary field delineated wetlands as well.
And is it correct that many of the 96 parcels contain between 3 to 5 wetlands on a single property?
I don't have any reason to doubt that some of them have between 3 and 5 wetlands on the property.
All right. And next, I'm going to move on. I'm going to ask you if you would agree that the majority of farm parcels purchased or leased by Earthrise for the project have likely been in production of agricultural farming for decades.
if you know, Rob.
I don't have any knowledge.
And is it correct that if agricultural land contained a wetland, but that wetland was being farmed prior to December 23rd of 1985, that a farmer can still continue to raise crops on a farm wetland?
I'm not aware of any regulation to that effect.
All right. Is it also correct that once a farm parcel is sold or leased and converted to a non-agricultural use, that previously farmed wetland now has to be protected under various state and federal wetland regulations?
Sounds like it's calling for a legal conclusion, counsel.
I don't think it is. Can you try to answer the question?
You know the answer to that question?
I don't know the answer to that question.
All right. According to the land lease and purchase records, Earthrise Solar was buying or obtaining leases for solar projects from 2023 through 2025. Is that accurate?
Yes.
And in 2023, were any of the farm parcels purchased or leased by Earthrise for this particular solar project left fallow and not farmed in 2023 growing season?
That was before my tenure at Earthrise, and so I can't confirm or deny that.
All right. And then you also can't confirm or deny, if so, how many parcels were left fallow. Is that correct?
Correct.
In 2024, were any of the farm parcels being purchased or leased by Earthrise for the solar project left fallow and not farmed in the 2024 growing season?
Again, most of that, I'd say most of that year I was not an employee of Earthrise, and so I can't confirm or deny that.
All right, let's try 2025. Were any of the farm parcels being purchased or leased by Earthrise for the solar project left fallow and not farmed during the 2024 growing season? I'm sorry, 2025 growing season.
Based on my understanding, no.
All right. So then they were being farmed, correct?
Yes.
All right. Your special use application for the solar facility was filed with Will County on November 19th of 2025. Does that sound accurate?
Yes.
In your preliminary site plan, and this is exhibit number 5 of our packet, which was Appendix L, under your sections for proposed conditions, and this is C-300, it's the main chart. I was unable to find a graph legend or a key to the right side of your chart identifying categories or a color code for farmed wetlands. I was just wondering why that was.
You're asking why farm wetlands were not identified on the site plan?
Correct.
Because we're not required to distinguish between the two. Right, because we don't make a distinction between farmed and non-farmed wetlands. We indicate wetlands, but we're not required to make the distinction between the types.
Well, I'm a bit confused because in the codes, you mentioned about delineated or inventory wetlands. Are you aware those are different from farm wetlands?
Yeah, I'm going to have to defer some of these questions to Mr. McFall. I think he'd be able to speak to these matters of policy a little bit.
That's fine. I'd be
detail than I
happy
can.
to ask Mr. McFall.
Yeah, let's do it.
Yeah, so for the National Wetland Inventory, they do show both farmed and non-farmed wetlands. So they are identified in the map. They just don't make the distinction either.
My question, I guess, then, sir, is if, as testified to, none of these farm fields were left fallow, how is it possible that Earthrise could have identified any farmed wetlands during this time period?
Can you repeat the question? Sorry.
Yes, certainly. So Mr. Calbus testified that, at least to his knowledge, at least in 2025, none of these parcels were left fallow and that they had been farmed during the entire time. My question is, how during the time period in which you were preparing your application, could you have determined where the farmed wetlands were if the land was not left fallow?
Yeah, so Army Corps of Engineer is pretty clear on the procedure for identifying both farmed and non-farmed wetlands. And so for field delineation, even if there are crops in a field, you can still identify what is a farmed wetland and what is not. If it's left fallow, you can also make that same distinction.
Well, if it is farmed, though, how don't you have to wait a substantial time for hydrophytic vegetation? Isn't that one of the requirements for a wetland?
That's exactly why it's called a farm wetland, is because it meets 2 of the 3 categories.
But it's being tilled. How are you going to see the hydrophytic vegetation and the hydrology?
That's the point I'm making. So it doesn't, the vegetation is the one category that is not, that doesn't meet the 3 criteria of plant hydrology and soil conditions, but you can still look at the soil conditions and the hydrology.
But how can you determine that if the farmer is farming the land? Because you can only look at the land at a certain time frame. Is that correct?
Exactly. Here in Will County, it begins usually at between April 15th.
Right.
And then when it gets too cold where you can't see the vegetation, you can't see the vegetation, that would make that third category. And so that's the timing, which includes during the farming season. So you can distinguish a wetland even if you have corn 8 feet high.
And just to be clear, the testimony has been that the site plan was delineated using the NWI report initially, and that was the site plan submitted in November 2025 and March 2026. So the delineations are primarily NWI report data set from the U.S. Fish and Wildlife Service. Secondarily, there are some field delineations in that site plan, but those are not required. The delineation that was required was the NWI data set. So the delineations that you find in the supplemental packet that we've provided have all of the wetlands delineated through both field delineations and the data set from the U.S. Fish and Wildlife. Is that right, Graham?
Correct.
Isn't it correct, sir, that once the farming is done, that then there are certain regulations that have to be followed with respect to farmed wetlands?
Correct.
Is that correct?
Correct.
Yes. And again, how can this be determined while the land is being farmed?
How can what be determined, Council?
Pardon?
How can what be determined?
Yes. How can the hydrophytic vegetation be determined when the farmer is farming it with agricultural tilling
For what purpose?
for agricultural purposes?
No, for what purpose are we determining hydrophilic plantings? To delineate the wetlands?
To delineate the wetlands that are present, because
Okay.
they will not show up while you're farming.
Right. So I don't want to go around in the circle too many times, but the site plan was delineated first and foremost using the NWI U.S. Fish and Wildlife data set. The delineations that you're referencing, I believe, are field delineations where you have to go out and look to see if the farmed wetland, if the farmed land is a farmed wetland. That was conducted as demonstrated through the supplemental report over a series of field delineations over the last couple of years. So for those field delineations, I just want to be clear what we're answering. For those field delineations, Graham, and I believe the testimony was also that this is seasonal, so it does require a seasonal operation. But Graham, for the field delineations, can you explain how you would delineate a farmed wetland?
Yeah, I think I answered this already, but there are 3 categories that tend to make up a wetland. However, if it's a farmed wetland, that's a different that misses that one category of the hydrophytic vegetation. That's why it's called a farmed wetland. And so as long as it meets the other 2 criteria, and you look at all the historical land use and you look at where the water is lowest and you do your soil sampling and you can figure out if it meets the 2 of the 3 criteria or not, and then it's called a farmed wetland. If it meets all 3 of the criteria, it is a wetland.
Yes, but you seem to be missing the distinction entirely here. We're talking about land that was not left fallow and it was farmed. Once that farming stops, then the land reverts back to a wetland. It's no longer considered a farm wetland. Isn't it correct that you then have to wait before making a determination of how extensive the wetland is once the farming has stopped?
We are still assuming that it is a wetland even after it is farmed.
But how can you tell the extent of the wetland while it's being farmed?
As I said, you see where it meets the other 2 criteria. And then it is converted to a non-farmed wetland after it is not farmed anymore.
I think we're going to move on because I'm not getting any answers that are legitimate here. Next, we're going to go on. I'd like to ask some questions regarding the capacity of the Earthrise project. Mr. Calaboose, do you think you can answer those, or is there someone else?
Yes, sir.
All right.
Back to Mr. Cobbs. Got it. Okay.
Mr. Calaboose, how would you define nameplate capacity?
We define nameplate capacity as the point of interconnection, the capacity at the point of interconnection.
So would this be considered the optimal capacity that your solar project could attain?
I'm not sure what you mean by the word optimal.
Well, is this the maximum capacity that your solar project could maintain?
At the point of interconnection, yes.
And could you describe what you're talking about with the point of interconnection?
The point of interconnection is where the power generation moves from the solar array, or technically speaking, from the step-up substation to the power grid.
All right. And you asserted, I believe, in your application that basically your nameplate capacity was 600 megawatts. Is that correct?
That's correct.
All right. And could you explain to the commission what a capacity factor is?
The capacity factor is effectively the amount of hours of the year that the facility is producing at that maximum capacity, at that maximum output.
So we could say that capacity factor is actual output as opposed to nameplate capacity. Would that be correct?
No.
And then can you please describe again what a capacity factor is?
Capacity factor is a dimensionless, it's essentially a percentage. It's a portion of the hours of the year that the facility is effectively generating at the nameplate capacity at the point of interconnection.
All right. And is it correct that Illinois is the 49th worst state in the United States as far as solar productivity?
I can't answer that question. I'm not sure what you're referring to.
You didn't look to see what Illinois' capacity was before you decided to put a project here?
We evaluate the solar resource and make a determination. And if the solar resource is sufficient to develop a facility, then we make a determination to move forward with the project.
We spoke with some ComEd engineers that informed us that the capacity for your facility was about 10 to 12%. Is that accurate?
The capacity factor?
Yes.
Our facility hasn't been constructed, so I don't understand how they could evaluate what the capacity factor of our facility is, our proposed facility.
What will be the actual capacity factor once your solar facility is up and running?
I can't give you an exact number at this point, but my understanding is the capacity factor will be north of 20%.
Okay, so basically you are only able to give 20% of the 600 megawatts. Is that correct?
Over the course of a year, the facility will produce over 20% of the hours of those years at maximum capacity.
So your capacity factor is not actually 600 megawatts, but it's only 20% of that. Is that correct?
Capacity factor?
Capacity factor is a percentage. It's a portion. It's not it. That's what a capacity factor is. You're implying that the capacity factor is a power, is an amount of power, is a rate basically of power production. That's inaccurate. It's a percentage. And I've stated that my understanding is that our capacity factor will be north of 20%.
Yeah. So you're saying it's 10% higher than ComEd has indicated. Is that correct?
We don't know what ComEd indicated.
And are you stating that ComEd made this representation, or an individual who works for ComEd?
An individual engineer from ComEd, correct?
On
Yes.
behalf of ComEd?
I don't know if it was done on behalf of ComEd.
Okay. So I think really the question is, what is the capacity factor? And I think that question has been answered.
It was, sorry, I can clarify. Yeah, it was on behalf of the data center. They said they could not use solar because it was so inefficient. So that was what he told us.
Okay.
And with respect to solar energy, so isn't it correct that your energy output basically is a bell curve? Would that be accurate?
I think that's one way to describe it, yes.
Wait, I'm sorry, the source that you were citing earlier was an engineer for the data center?
No, it
Not
was
from
an
ComEd,
engineer from ComEd regarding the data center.
regarding the data center. Okay.
Correct, correct.
Just want to make sure. I
And
understood.
so if you have the bell curve, which we talked about, is it correct that the solar project only provides peak energy during 2 or 3 hours of the day?
Approximately, yes.
All right. And it does not provide power at night or on cloudy days. Is that accurate?
That's not accurate, no.
What kind of power is generated at night?
De minimis power at night, but on the facility is definitely capable of generating electricity on cloudy days.
And yeah, at what percentage on cloudy days do you get from the sun?
I can't answer that. It's really going to depend on a number of factors.
And I think representation was made at the last meeting that Earthrise would power 110,000 homes. Is that correct?
Approximately. Actually, I think we stated 120,000 approximately homes.
Okay. So isn't it correct, though, that because it operates on a bell curve, you're only would be powering these homes for 2 to 3 hours a day at a maximum capacity?
Well, we were using that as an equivalent factor. So we were saying the equivalent factor consumed by 120,000 Illinois homes over the course of a year. It's essentially equivalency. We're not saying that it is powering those homes. We're saying that the power output is equivalent to that which is consumed by 120,000 average Illinois homes in a year.
Okay. So then basically, are you just producing 120 megawatts? Would that be accurate?
No, that's not accurate.
Well, if it's 20%, then isn't that 120 megawatts?
Mr. Becker, I think you're confusing a rate, which is megawatts, with a quantity, which is energy, which would be stated in megawatt hours. So I think you're confusing a few things here, and it's difficult to answer those kind of questions when you're really not stating them accurately.
Well, that's why I'm asking you, because you're supposed to be an expert.
So what's the question?
So what, yeah, can you restate your question then?
How many megawatts are you actually producing through this facility when it becomes operational?
The facility at peak production will be producing 600 megawatts at the point of interconnection. That power is a maximum, and as you stated, over the course of the day, that power output will be variable.
So is it only at 2 or 3 hours a day then that you were putting out these 600 megawatts?
Approximately, yes.
Okay. Now I'd like to move on. In the final staff report, this is exhibit number 4 at page 5. It states that based on the concept site plan, an estimated 16,921 panels, 1,190,868 modules will be located on the requested special use area of 6,099 acres. And my question is, does your use of the term panel equate with an array?
A panel is a component of an array.
So in this statement, did you indicate how many arrays are on your project site?
I'm not sure what you're asking there.
Well, it lists that based on the concept site plan, an estimated 16,929 panels and 1,190,868 modules would be located on the special use area. Does that statement indicate how many arrays you are going to have on the
So
site?
the 16,000 number, that figure is unfortunately a typo that was carried through. We use the terms panels and modules interchangeably, and the approximately 1.2 million that is shown on there is the accurate number to the right of the typo.
Okay, and what is incorrect in the typo?
The figure, the 16,000, approximately 16,000 figure.
Okay. Are the modules the panels themselves then?
We use the terms module and panels interchangeably.
Okay, so there's nothing indicating here how many actual arrays you have on the project site. Is that correct?
Can you define array?
I'm asking you to define an array, please.
Well, that's not what you're asking. You're asking how many arrays are there, and I'm first asking you to define what you're asking me to quantify.
Well, I asked you whether the term you used here, panel, you were referring to an array.
A panel is a component of an array.
Yes, so my question was, based on this statement, is there any indication in here how many arrays you have on your project site?
We define the entire project, the entire infrastructure as an array.
But aren't there structures on which the panels are kept?
We refer to that as racking. And so, yes, we talk about racking.
All right. Is there any indication in this statement of how many racks there are on the project site?
No, it can be implied by the panel count. I think we could back out to one, but it's not stated explicitly.
How many panels are there per rack?
Can you repeat the question, Mr. Becker?
Yes, sure. How many panels are there per rack?
I don't have an exact count. I think that's something that we're still finalizing, depending upon the models that we're evaluating.
And how many steel posts are contained in each rack?
It really depends on the model of the rack, for the racking.
Do you know yet what model you're going to be using? for
We
the
haven't made a
project?
final selection now.
So is it correct that at this time you cannot tell us how many steel posts will be put into the ground in the project?
I could give you an estimate.
Yes, please do.
I'm going to refer to my colleague, Mr. Horn, for
Okay.
that estimate.
Sure, that'd be fine.
Yeah, that's approximately 300,000.
And this is an estimated number, is that correct?
That's correct.
All right. Now I'd like to turn your attention to exhibit number 8 in our packet. Is it correct that the Will South Cook Soil and Water Conservation District prepared a natural resource information report assessing the soils on various project sites for suitability?
Yes.
And what are the 3 categories they use to assess suitability?
Can you refer to us?
Yes, sure. I can refer you to page 32.
And
I don't see criteria referring to suitability. Perhaps you could define what you mean by suitability?
Yeah, well, there are 3 soil categorizations on that page, and I was wondering if you could please identify those for me.
I'm not sure where you're asking.
There's a
Are
grade-
you asking for the not limited, somewhat limited, and very
Correct.
limited categories?
Correct.
Okay, so for the record, we're looking at this page 32, and the document has a not limited, somewhat limited, and very limited category. And that's what you're asking about?
Yes, that's correct.
Okay.
That's correct. On the same page toward the bottom, isn't it accurate that very limited is defined as, quote, indicates that the soil has one or more features unfavorable for the specified use?
Did you read that accurately?
He read that accurately, yes.
Okay, thank you. And on the same page, Soil and Water determined that every one of the parcels in this project rates as high for steel corrosion. Is that correct?
It's what the report says, correct.
And is it correct that under the heading explanation of limitation ratings, under the subtitle solar arrays, that it states soil penetrating anchoring systems can be used where the soil conditions are not limited? And that's following page 33.
On page 33. Yes, that's it. That is accurately stated.
Very good. And turning now back to page 32, is it correct that every one of the soils listed here are either somewhat limited or very limited in this project,
Yes, that is correct.
right? And if that is the case, why have you chosen this particular location where all of the soils are unsuitable for your project?
When we make a determination about siting, we rely on a range of experts to advise us on suitability. And, although this recommendation is considered, we rely on a range of recommendations. And the experts that we're working with believe that the site is suitable for solar development.
So is it correct that you do not consider that South Cook Soil and Water Conservation District is competent to make this determination?
I don't agree with that statement, what you just said, no.
Turning your attention now to page 35, isn't it correct that the properties on this particular map, which includes the parcel next to Donis Robeson's property, are covered with unsuitable soil types for steel pilings for solar arrays?
There's no legend on this map, so I can't really make that determination.
Yeah, the legend is on page 32. And so those colors are then indicated on the maps?
Again, I don't have that color coding is not on the map, so I can't make that determination.
You can't see the color on the map that we
I can see
provided?
the color on the map, but I have no reason to believe that color coding on that map is consistent with the color coding on page 32. I see yellow, red, and green color coding on page 32. And on the map, I see yellow and orange. I don't necessarily have any reason to believe that this is referring back to color coding in this chart.
Even though the map says solar panels on the top, solar arrays?
I mean, the word solar is used quite extensively in our application.
Great, well, let me then turn your attention to pages 99 and 103 and the same exhibit, and these concern corrosion of steel and represent project parcels next to two of our clients, Donna Robinson and Jim Mickelwitz, and Russell Wilkie. Isn't it correct that these maps indicate that none of the soils are suitable for steel corrosion?
Based on the information on the map, I can't really make that assessment. I'm not really familiar with this map's color coding on here, so I can't, I can't agree or I can't deny or confirm that.
I think the characterization as unsuitable is, I'm not sure that accurately reflects what these maps are demonstrating, even if your representations on the key are correct.
Well, isn't it correct that this map is entirely red?
Page 99.
Yes. That the parcel location, everything is red on that map.
Yes,
And doesn't that?
all the color coding on the parcels is red.
Yeah, and doesn't that correspond with the legend that we read you earlier on page 32, that this is very limited?
There's red text on page 32.
And doesn't it say steel corrosion is high, and that is all in red as well?
I think it might actually be referring to this. Might actually be referring to this anyway.
I mean, the red text is used in a number of the columns on that chart on page 32. So I don't know which column that red is referencing back to. It's very difficult to read this. It's very blurry text, very small.
Yes, the bottom of page 32 reads that there are colors, and these define the risk of the impacts to soil moisture and soil structure. So there it's either green or there's yellow or there's red. And my question is it correct that the soils indicated on those two pages I just read you are completely red?
I think, council, we can stipulate that on page 99, the properties. Oh, no, we've got,
Well, you can read,
yeah, I can.
you said it was blurry. I was trying to figure it out.
Got it.
Again. Okay.
Thanks. We can stipulate that the project parcels identified on page 99 are red.
Okay, thank you.
Yeah.
And how can you proceed with a 45 square mile project for solar panels when the Soil and Water Department has indicated that none of these soils are suitable for your purposes?
I think that is assuming a fact, not an evidence.
Well, isn't it correct that Soil and Water found that every one of the parcels on this 96 parcel property were of at high risk for corrosion?
That I think is true.
So yes, it indicates that there is high risk for steel corrosion in the chart, yes, on the parcels identified.
Okay, and then I'd like to now turn to those particular steel posts. In your project narrative, this is going to be exhibit number 3 at page 25. Earthrise indicated, quote, steel posts are installed approximately 6 to 10 feet into the ground. Is that accurate?
Yes,
All right. And these are, there's zinc coating on these galvanized steel posts. Is that accurate?
the zinc alloy,
Yes. And you are not encasing any of these posts in concrete for the project. Is that accurate?
no, they're driven and held in place by friction.
Okay, so you're not encasing them in concrete, Bill?
Correct.
Okay.
Correct, yeah. Sorry.
And during your presentation at the PZC hearing, one of your witnesses stated that the steel posts would cause, quote, minimal leaching into the soil. Is that accurate?
That's accurate.
All right. Isn't it correct that placing galvanized steel posts into hydric soil dramatically increases the leaching of zinc into the soil and groundwater?
I'd have to defer to our expert testimony, and our expert, Dr. Chris Olson, testified that leaching would be minimal.
Yeah, the question was though, if that's not the question. The question was when you place galvanized steel post into hydric soil, does it dramatically increase the leaching of zinc into the soil and the groundwater?
Council, this subject matter was testified on from Dr. Chris Olson back on March 30th, a witness you have waived for the presentation here tonight. So Mr. Kalbas can, respond to the extent of his knowledge, but, Mr. Olson testified, for example,
Just a couple of pages.
Well, I didn't waive testimony because we asked about the structures that you were going to build. And obviously the steel posts are an integral part of that structure.
I didn't say that you waived testimony. I said you waived the witness, which was Dr. Chris Olson. So like I said, you can ask Mr. Kalbas these questions. I just don't know if he knows the answers to them. We had an expert here to testify on these exact topics. Mr. Olson testified that the galvanized steel results in a very minor amount of leaching from the zinc directly right beside the pile itself. It doesn't impact crops. It doesn't impact the farm field, and it doesn't impact agricultural productivity. So that's the testimony that we've heard already on this topic. If you have questions for Mr. Kalbas, then he can do his best to answer them.
Yes, and I will. And I asked Mr. Calabuz, isn't it correct that placing galvanized steel posts into hydric soil dramatically increases the leaching of zinc into the soil and the groundwater?
I'll have to defer to the expert's testimony.
And is it correct that over 1/3 of the soils in this project are on hydric soil?
Based on the findings of, yeah, correct. Yes, that's accurate based on the report.
And you would have, I think you testified, you would have over 300,000 posts in this project. Is that right?
Approximately.
All right. And how many of these properties in your project are connected to waters of the United States?
When you say connected, can you explain what you mean by that?
Yes. Do you know what waters of the United States are?
I have a working understanding of waters of the United States.
All right. And are you aware of what waters of the United States are? Could you tell me what they are?
My understanding of waters of the United States are navigable waters.
Do they include tributaries?
And tributaries to navigable waters, yes.
And do they include wetlands that are adjacent to waters of the U.S.?
My understanding is it's based on hydraulic connectivity to a navigable waterway.
Are you aware of the United States Supreme Court's landmark decision in Sackett versus EPA?
I'm not.
All right. And are you aware of what happens when zinc leaches into the soil as far as agricultural purposes?
You're asking me to speculate about something that really depends on a range of variables, and so I can't really
Are
provide
you-
a response to that.
I'm not asking you to speculate. I'm just asking if you know what kind of impact that leaching zinc has on agricultural soil.
You're asking me to speculate about an impact, and so I would have to understand the circumstances to speculate on that impact. I'd have to provide more information.
Do you know what impact that zinc has on aquatic life?
It would really depend on the concentration of zinc.
And do you know what kind of impact that leaching zinc would have to humans if it is consumed?
It would really depend on concentration.
There are numerous adjoining landowners with wells next to the Earthrise properties. Is it correct that if zinc leaches into those aquifers, it would invade their drinking wells?
I'm sorry, can you restate that?
Sure. Is it correct? I was saying that numerous adjoining landowners, as indicated on your maps, have wells. Are you aware of the impact that that could have to their wells if zinc leached into the water supply?
You're assuming that zinc is going to leach into the water supply, and Dr. Olson testified that it would not.
I believe he said it was minimal leaching. He didn't say there would be no leaching, correct?
I believe he testified that the leaching, to the extent it occurs, happens right at the base of the pile, that it's constrained there, and that it doesn't affect the wildlife, the agriculture, or the vegetation.
Yeah. Right.
So to assume that it has gotten into the groundwater is a pretty far leap, counsel.
Your project expands 45 square acres. Isn't it correct that if there's even minimal leaching of zinc, this poses an incredibly dangerous public safety and environmental risk?
I don't agree with that statement.
All right. All right. Thank you, Mr. Kalbus. We are done with our cross-examination. We have 3 short witnesses to call on behalf of the plaintiffs. So first, I would like to call Melissa Egger.
Make sure your mic works. Make sure your mic works. Okay.
All right. Would you please state and spell your name for the record?
It's Melissa Tab Eager, Melissa Melissa, Tab TABB hyphen Eager, EAGER.
Thank you. And what township do you live in?
I live in Will County on Stunkel Road in Green Garden Township.
Right. Based on your experience, do you have an expertise on caisson pilings and soils?
I do. I have over 30 years in the caisson drilling, implementation, and engineering field.
And can you explain to the commission exactly what caisson pilings are?
Basically, we go in with machines and make unbuildable land buildable, structurally sound, most of the time in areas where water is present.
And what kind of projects specifically did you work on through your career?
Oh, residential projects. We've done several high rises downtown, the foundations that go into those. A lot of residential projects in the south side, in the Moraine Valley area, in the wetlands created by the glaciers 10, 15,000 years ago, Will County, wherever there's water present or soil conditions don't allow the foundations to be stable.
And how do you correct that?
We correct it by taking an auger, which is basically a big drill, drilling into the ground, removing the soil, and then casing it to keep the material and the water back. And then as you go down, you have different levels and types of soil that will cave in or then run into the shaft. So what you do is you take it out and you put a steel sleeve in, and then you pour concrete into it. And as you're pouring concrete, the concrete holds the walls back and you pull the casing out at the same time. And then you put in steel rods similar to just rebar cages, depending on the specifications of the engineering, the structural engineering. Some of them are coated with epoxy. Sometimes they are straight into the concrete, but then you put them into the concrete, and then later on, usually after a couple months, they'll come in, dig it out, and then that's what the foundations of the homes or the structures will go on. So it's almost like creating a floating land underneath the ground in order to make it strong enough to hold the structures above.
Thank you. Can there be a negative impact to soils and groundwater where galvanized steel posts are pounded into the ground?
Well, definitely. You don't have any protective layer from the galvanized posts. Anything put into ground that is wet is going to eventually leach out. That's why when we, for instance, do the caissons, we have inspectors there. As this temporary casing is pulled out, the concrete has to push back and hold, and those holes have to be completely dry, or else they get refused. So when you're putting steel into a ground without any protectiveness around it, whether it be epoxy or concrete casing, you're creating an environment where something's going to corrode, it's going to fail, and that's why caissons exist.
And what happens when the zinc leaches from the steel?
Well, it depends on the type of soil it's in. It's usually going to be leaching if it's in a hydric soil. And it also depends greatly on where the water table is in the areas. Water tables vary. You can go into a 10-acre parcel and soil borings will show the water table can vary within 10 feet of where you're drilling. That's why multiple soil samples are so important. We've worked in some areas where you drill a hole and, 15 foot here, you've got a dry hole. You go 15 foot over, drill the exact same size hole, and you hit a seam of water or the water table, and it floods out. And you have to stop what you're doing and have engineering come and change it. So what's going to happen is you've got these layers of different soil. You've got sand, you've got dirt, you've got rock, you've got seams of gravel. You've got what may have been there prior to us being here, previous buildings from 100 years ago. But if you have water tables, everything just comes flooding into it. So everything gets mixed up. So what's going to happen is anything that is corroding on something put into that soil is going to get into that water table. And it goes everywhere. It's going to have the ability to travel because it's water. It gets carried. And the water table in Will County is very high. I think anybody that has septic fields, anybody that has wells, understand this from living there. So.
And is the leaching of zinc exacerbated in hydric soil?
Oh, yes, because it's wet. Simple, it's wet and it corrodes. And depending on how the galvanized poles are galvanized, if they're hot dipped, it's a little bit better, or if they're done electrostatically. Just to point out something that is just to note, if something is funded by Illinois, by the state of Illinois, their building codes mandate any steel, even if it's encased in concrete, be epoxy coated. You can't even touch it unless it's epoxy coated and into steel. And I'm talking for small signposts that may be up and down the tollway or 294, which, the company that I worked for did thousands of over the years. So, yeah.
And how quickly would zinc leach into the soils in hydric soil?
Well, as soon as it corrodes, it's going to leach into it. A pinhole into that galvanization will corrode. There's studies that show, standard galvanized pole will last in studies, upwards of 10 years. But when put in a hydric soil or wet locations, it's usually anywhere from 3 to 5 years. It begins, and that also depends on the quality of the galvanization and also how the galvanized steel poles have been stored. from the manufacturing facility. You can't store them in heat. It degrades the galvanization. You have to handle them properly on site if construction workers are banging them around, or if they're unloaded properly and there's any type of dings that causes instant ability, a failure of the galvanization. So when it touches the hydric soil and the water table, it's going to erode.
And is the only way then to mitigate this type of corrosion is to encase those posts
Yes.
in concrete?
Yes, it's going to drastically reduce it and give you the life, give you, 15, 20, 30 years before it's going to corrode, because concrete corrodes at a much less rate than galvanized. I think the studies even show it that we were referring to earlier. There's minimal corrosion with concrete, but high corrosion in steel in this hydric soil. So epoxy coating of the poles and encased in concrete would substantially lower the risk for the residents and the wildlife in the area.
So if Earthrise, for example, did encase all these posts, it could mitigate the damage, but it also you would never be able to return the land for agriculture.
That's what I was going to say. So the only issue that I would see with that, just from my experience, is when you're now encasing in concrete, you're taking that soil out in order to put the concrete in its place. So you're talking displacing a lot of the wetland area, or the farmed wetlands, or whatever we're going to call it. But basically, you're taking soil out. That soil is then going to be displaced. The biggest issue with this area is what's called silty loam soil. It's combined of silt and loam. Silt is about 60 to 80% in silty loam. Silt is like a very fine sand, and it's very round. And when sand is round, it leads to compaction. And the loam is 20 to 40% in a silty loam, and loam is angular. The loam is what will hold the water. That's what makes it moist. That's what makes these areas where people are farming so healthy to be farmland. The soil retains moisture when the silt is not compacted. That's why it's good for farming, because they plow every year. But when you're going in there, for instance, if they were to encase each of these galvanized poles into concrete, it requires heavy machinery, large machinery. So that's going to compact the silty loam. The silt in that loam is then going to compact and become hardpan, very close to the surface. And what that's going to create is, a lot of things. It's going to cause surface erosion. So when water comes through, it's not going to be seeping into the ground, because you're going to get a compacted silt layer. And it's just going to stay on the surface, and then it's going to create a lot of soil erosion. When silty loam is compacted, it creates erosion at the surface. And then you're going to have a lot more water runoff, because this soil is now compacted underground, so it's no longer has the absorption rate. And you compound that by these tens of thousands of poles. Even if they were to solve the problem of the leaching of the zinc from the galvanized poles, then you're going to have the issue of replacing all this soil with concrete and displacing it and using heavy equipment to do it. These conditions, it makes it you're just going to create a bunch of hard soil, and that's going to cause a lot of water problems. So,
And lastly, once the zinc would permeate into the soil, is it correct that it could go through the groundwater and enter into other water bodies?
well, definitely. Because of this hard pan being created, the water that's going to come into the soil, you're going to hit that silt layer that's been compacted, and that's going to hold the water there. So the water is going to displace underground, and it's going to be closer to the water table. So you don't need to be that far down to cause contamination of the water source when you've got it's almost very similar to putting, when you create a hard pan of silt underneath something, it's very similar to putting a layer of weed barrier in your garden. You're basically putting a barrier where the water is not going to get through. So that water is going to find its way. And usually it finds its way into streams, into wetlands, or it's going to create its own erosion. It's going to erode the land, and it's going to find its way to the lowest spot, which is usually the wetlands or the streams that nearby. So, yes.
Good. Thank you very much for your testimony.
I have a few questions, if that's okay. Thank you. Is it Ms. Eager?
Sure.
Were you here for Dr. Olson's testimony on March 30th?
I do not believe I was, no.
Okay. Do you have any reason to doubt Dr. Olson's credentials?
I don't know what his credentials are to say either way.
Okay. I understood that your testimony is based on your experience in the drilling and implementation field, correct?
Yes, case on industry for over 30 years. I've actually seen the different soils, interpreted the soil borings, worked with engineers. I've used the equipment to drill the holes. I have placed the concrete into the holes. I've done all aspects of caisson foundation work.
Thank you, Ms. Eager. What's your highest level of education?
I have quite a bit of college, and I'm a 150 local operating engineer. So I'm a tradesman also.
Gotcha. Thank you. Do you have a college degree?
No, I'm a little short of it.
Okay.
But I have extensive experience that there is not degrees in caisson drilling. It's actually not even taught at the union site. It's on the job, and you have to learn in the field because, as I was saying earlier, every few feet is different in soil
I understand.
underground. So
But you don't have a college degree in chemistry or soil chemistry or agriculture?
I am not a geotechnical engineer. No, not of course. And I've had plenty of soil engineers that come out that don't understand how to stop water from filling up a hole.
I understand.
To understand what a piece of dirt is and how to make it a safe hole are two very different things. That's why there's operating engineers and caisson specialists and then geotechnical engineers. It's two different.
I understand
It's
that your
completely different.
I understand that your testimony is based on your experience in the field,
Correct. Extensive experience.
but not on a formal college education.
Well, there isn't one for this.
Okay, I understand that. What was the name of your company?
It was Foundation Drilling Co. Inc. It was about 72 years. It was a family-owned business. I have extensive family members that have always been in the business. We're pretty widespread, actually, throughout the country, many of us.
And what was your position at that company, your title?
I started as a laborer in the field to learn properly, and then I moved up to operating engineer, operating the equipment. I'm the first woman in the country to ever run a drill rig, actually. And then from there, I became a superintendent in the field for several years. And then I transitioned into the office, and I was president of the company for 12 years prior to it closing. It is closed now. So
Okay, when did it close?
it closed when I decided to retire and take care of my mother 6 years ago.
Okay, 2020?
Approximately. About 2022, I finally closed it. So 4 to 6 years.
Do you have a license as a structural engineer?
No.
No
No,
certifications for engineering?
I am a caisson operating engineer. I'm a certified.
No, I understand that.
Well,
But I mean-
operating engineers are qualified individuals.
Okay.
So we have a very large training site and there's ways to, yeah. So, I mean, I take a slight offense to that.
Okay, I'm
There's
sorry.
no well, I'm just saying, there's no college that teaches you how to drill and install caissons. There are structural engineers that we work with that many times when we're in the field doing the holes, and then we have soil inspectors that also take soil samples. They test the concrete on site, they test the soil, depending on how far we are, if we have to go deeper. And then there's many times that we then have to go back and discuss our findings in the field and work with the engineers, the structural engineers, to determine if they want to stay with what they had designed, or many times because of what we find in the field and what we advise them to do, they have to go back and change the structural integrity of the caissons. So we work together, and we both have specialized education for that.
I appreciate that. But we're talking today about soil chemistry and about hydrology.
Well,
And
actually-
those- And I'm sorry, you have to let me ask my
Go
question,
ahead.
and then you can provide your answer. So, on those topics, there are degrees and certifications. And I
Yes.
do understand that you have experience, and I'm not trying to suggest that your experience is anything less, or that you're not experienced in the caisson industry, as you've adequately demonstrated. I'm just trying to figure out, because this is the first time we've met. I've never asked you any questions before in my entire life. I don't have your resume in front of me. I don't have your LinkedIn profile in front of me. I'm just trying to figure out what your basic education and training is. So that's all I'm trying to do.
Not a problem.
Okay.
So do you want me to tell you my history of my educational training and my previous jobs? I mean, how in-depth do you want? What I'm saying is that,
I think I think you've answered the questions that I've asked, and
Okay.
I appreciate that.
okay, thank you.
Your company, Foundation Drilling Co., you said did mainly residential high-rise?
No, not at all.
No.
No, I said in the areas of Will County and the areas of like the Palos, Hickory, where the moraines came in and the glaciers from, where the land permitted, we did a lot of residential. We've worked, well, I would say probably 80% of the sign poles you see on the side of the expressway was done by foundation drilling over the decades. We would tap out at, we would go down maximum 80 to 100 feet before we would usually, our equipment, it depended on the type of equipment you had, how large of holes you could do. But we also did many buildings downtown, 8 to 10 story buildings. We've done residential, we've done holes anywhere from 24 inches to 10 to 12 foot in diameter, going down upwards of 100 feet.
Have you ever done a solar farm?
Well, no, because I've not known a solar farm to use caissons. I have worked extensively with ComEd, though, inside the ComEd substations.
Uh-huh.
So understanding some of the things we need to do within the substations. So I have worked putting in the platforms to hold the transformers.
Okay. Do you know how many solar farms or solar energy facilities Will County has approved to date?
I do not.
Do you know if Will County has required any other solar farm to coat its galvanized steel piles in epoxy or other material or concrete? Do you know the answer to that question?
Will County? No, I do not.
Okay. One moment, please.
We don't have staff members.
So I told Tim, they're telling me this is up planning, so it brings their own staff. And their corporate control, that was like used. I guess it's all the people over there. He was here in. You think this is the biggest thing going on in your land use department? You'd be here. Agree. I guess this way, if you're not here, you don't have to answer any questions. Any time we leave.
I'm not qualified to answer the question.
I'm gonna volunteer you though.
Okay. Oh, wait. Not unless I could run in circles for 10 minutes and then drop it. Well, I don't know. Yeah.
Really? Graphene and advanced concrete?
I got it all set.
Sorry, I am not a galvanized steel expert, so I had to consult with my construction people.
I'm not a galvanized steel expert either, but I do feel I have expertise in soil conditions underground.
Okay.
That's what I'm here to testify about. Can I
That's
just
fair.
answer a question that you asked earlier about Will County providing or requesting epoxy? In addition to the answer I'd given, I'd like to say that I don't think Will County has seen adequate soil borings to tell them what the soil is. We're doing all these opinions based on walking the earth. You don't know. Just as I had mentioned, structural engineers change things many times once they see what's happening in the soil. And I think that soil borings in these installations would be very important to do.
Mhm.
So,
Are you aware of how long solar has been installed around the country?
no, I have no reason to. I'm here to testify regarding soil conditions.
I know. I'm just, and the follow-up question is, are you aware of any solar facilities around the country being required to coat galvanized steel piles in epoxy? I would assume no.
I think, I'm not aware of specific ones, but I think that there are plenty of companies that epoxy steel that would answer to that and say, be strongly suggested in hydric soils.
Okay, yep. Um, do you have, I take it you're testifying here today, you don't view the project favorably. Is that a fair characterization?
I'm not against solar. I wouldn't say that. I would say that I'm concerned for
Mhm.
two reasons. I'm concerned knowing what hydric soil does to steel.
Are you opposed to this project specifically?
At this point, until more information is properly given to make educated decisions based on the health and welfare of Will County residents
Yeah.
and their water supply and the livestock, I'm concerned, yes. As not only someone that lives there, but someone that does not see any adequate studies done to tell us what's underneath the ground that they're putting these poles into. So I'm
You-
opposed to that, yes.
Okay, I understand. You-
Unless the soil conditions aren't hydric, but everything indicates it is, that they're telling. I think soil borings would be a really good thing to do.
Did you collect signatures in opposition to this project?
I collected signatures for awareness of
Did
this
you
project.
collect signatures in opposition to the project?
I collected signatures surrounding Aaronwood, not to this project. No, I did not.
You
Not
did
to Earthrise. No, I did not.
Okay. Did you create no solar signs for use in these hearings?
I did. I said no solar farms. I
Okay.
did. That was me. Correct.
Okay. Um,
Thank you. I think they turned out nice, so. Thank you.
there's no, I have no further questions. Thanks.
Thank you very much. Then we'd like to call our second witness, Jim Mikowitz, please.
Down.
Good evening. Could you please state and spell your name for the record?
Okay, my name is Jim Michaelwitz, Michalewiczz.
And Mr. Michaelitz, in what township do you reside?
We're in Green Garden Township.
And where are you located as far as the crossroads?
We are next to the last farm from Offner and Shear Road.
All right. And are you an adjoining property owner to one of the parcels on the proposed Earthrise project?
Yes, sir. They are they're all to the north of us.
Okay.
From Shear Road over through about halfway east on Offner Road.
All right. And did anyone from Earthrise come to consult you about water problems you were having on your property prior to filing its application?
No, sir.
All right. I'm now going to show you what we have marked as two photos. And this is Exhibit 9 for the applicant in our packet.
Okay. All right, the top picture here, I was probably zoomed in, went to the back deck of the house and
First,
shot.
Mr. Michaelwitz, could you describe which one of the two photographs that is, please?
I say again, please.
Yes. Could you describe what's depicted in the photograph?
Oh, flooding.
Okay. But there's two different pictures. Could you describe what the first picture indicates?
Okay, the first one here indicates all flooding to the north and back on our property here. I believe that's Fork Creek right here that you can barely make out. The top picture here shot a picture to the west and you can see Shear Road Bridge and the water is up to the base of the concrete. And I don't recall if it was quite over the road, but it was just about to the top of Shear Road.
Okay. And Mr. Michaelwitz, did you take both of these photographs?
Yes, sir.
And when did you take these photographs?
That was probably the first weekend in April, the 3rd and the 4th.
Okay. And would you say these appear to be true and correct copies of the photographs that you took on that occasion?
Oh, definitely.
All right. And are you concerned about the flooding aspects if the project goes through for Earthrise impacting your property?
Absolutely. I'm not only concerned about myself, but my neighbors and everybody.
Right. Very good. Thank you
Okay.
so much for your testimony.
No problem.
Yeah, great, great. Mr. Jacoby, did you have any follow-up questions or?
No, sir, thank you.
Okay. And then the last witness that the plaintiffs would like to call is Donna Robinson, please. While he's checking on the video, could you please state and spell your name for the record?
Donna Robinson, Robinson.
And Ms. Robinson, what township do you live in?
I'm in Green Garden.
All right. And what are the adjoining roads that are near your property?
I'm on 104th, about half a mile from Manhattan Money Road and Raleigh.
And is your property adjoining one or more of the parcels in the proposed Earthrise project?
Yes.
Right. Now we're going to show a video. Go ahead. Great. You should be able to see this on the screen, and then I'll ask you about it.
This is along the south side of my house. Then this goes to the back. And this water right here also comes from Prairie Schooner. And my neighbor's yard never flooded like this before. And this runs along the back of my house, which shouldn't be this wide. And we've come to call this area back here Cheeky Lake because how the water sits there. Then it goes into a tunnel that I have.
Great. Thank you so much for your technical expertise. Ms. Robinson, could you please describe what was in the video?
I flood all three sides of my house. About 4 years ago, I contacted the, what was it called? Excuse me a minute. I contacted Land Use Department, and I told them that I have water on three sides of my house. The landowner north of me never maintained the culvert that goes through their property. And then the farmers would drive over it, so they stopped the water right there. So all the water that's supposed to go through their culvert to the culvert on the street to the creek, it doesn't go because they stopped it. So everything stops by me.
And Ms. Robinson, did you take that video?
Yes, I did.
And when did you take that video?
Oh, a few years ago.
Okay.
And then I called the Army Corps of Engineers and I sent her all the information I had and all the videos, and we had a few calls back and forth, and then she never contacted me anymore after that.
And Ms. Robinson, was that a true and accurate copy of the video that you took?
Yes.
And on the video, it showed a large area to one side of your property. Was that the area where the proposed solar parcel is?
No, that's the dry pond that never dries. And we kept going straight and then it should turn. But where it turns, then it would be the parcel next to me, to the north of me.
And are you concerned if the solar panels put in that you will get even additional water on your property?
Of course I do.
No further questions. Thank you so much. All right, that would conclude the cross-examination of the plaintiffs and our presentation of evidence. Thank you for listening.
Thank you. Are you also complete?
I only had one final closing remark, and that is that as the special use, oh, actually, I'm sorry, Mr. Becker, I did have a question. Did we get Ms. Eager's home address?
Did we give it?
Yeah, what is Ms. Eager's home address, please?
If you don't mind.
I don't know why they need it. Sure, it's 9319 West Stunkel, Stuenkel Road. And that's in Frankfurt. Green Garden,
60423.
60423, correct. Anything else?
Thank you, Ms. Eager.
Okay, thanks. If you were looking, you may see me still in a different location. I have been here and have residency here since 2020. I own and I live on property, so that may be what you're wondering, because I did originally move from Hickory Hills. So a lot of things, if you're looking online, will show that. So
I had no idea. I was just
yeah.
wondering if you
Okay,
were
well, just to confirm, I've been in the community of Green Gardens for 6 years.
Okay,
So
thank you.
thanks.
Okay, I'm sorry. So I wanted to close by asking this commission, you're now being asked to vote again, having already voted once, and we know that the first vote was a recommendation for denying the project. I hope that this exercise has changed your minds and that you'll vote in favor of the project, and we of course ask for you to do so. However, I would also ask that you consider amending the proposed conditions consistent with the conditions that were adopted by the county board for the Plum Valley Solar Project. So the county board has executed an ordinance that reflects conditions to that project that mirror in large part the conditions that are proposed here. However, there were some amendments made by the county board at the county board meeting. And I just felt it an efficient use of time to suggest that this county, or that this planning and zoning commission adopt those amendments into the conditions and then vote on the amended special use permit. So for the record, the amendments that were proposed and accepted for the Plum Valley Solar Project, I want to make sure I'm matching this. So for this project, the condition number 3 currently reads, on-site power lines and utility connections will be allowed above ground if required to avoid existing obstacles such as pipelines or wetland areas. And we propose keeping that language. We'd ask that the following sentence be added. Provided, however, that the project is approved to utilize the cab above ground cabling system between panels as described by the applicant at the hearing. And if you recall, the presentation back now over a month ago demonstrated the underhang wiring system between the panels that is easier to access for both safety and maintenance reasons. And we showed some pictures of that. And so to the extent the ordinance requires an express approval of that system, we'd ask that express approval be provided in condition 3. And it was approved by the county board, again, for the other project. Condition 7, which is actually not, which was added by the land use committee, had originally said that the fire lanes shall be gravel. And we have no objection to that either. the amendment that we had requested and approved by the county board revised that condition to state the following: notwithstanding any other provision in the Will County Code, including Chapter 164 of the Will County Code, the fire lanes, including access roads, shall be gravel per the request of the fire departments. Any such gravel lanes shall be considered pervious under the Will County Code. And this was discussed at the Land Use Committee in some detail. The fire departments had requested that these fire lanes be gravel, and the pervious nature of gravel roads is just being explicitly provided here so that there's no confusion at the site development permit, because your ordinance is otherwise a little vague on that topic. And then finally, condition 8, which was proposed by the Land Use Committee, states the following. And again, this is the original language: prior to the commencement of construction or issuance of a site development permit on any parcel affected by the special use permit, the applicant will negotiate and have executed a road use agreement with each of the township road districts and post road district surety bonds as required by such agreements. We don't object to that language. We'd ask that the following be added: consistent with the Will County ordinance. And that was also accepted by the Land Use Committee and the county board ultimately. So those were the 3 revisions that we had proposed. At the county board level, they were approved for the other project, and I wanted to bring them to your attention to make for a clean record on this project. With that, thank you very much. We would ask that the commission close the public hearing, and we hope that we've earned your vote.
We don't have that because she's here in front of us. No, we don't have the condition. Yeah. Mr. Chairman, would be allowed to ask questions of Mr. Becker and Rob and I got it written down. Mr. Jacoby and Mr. Kovas. Yes.
Yes, sir.
Yes. Anybody want to go first? Okay, so I guess I would, a lot of legal posturing was done about wetland delineation. Would you be putting, is it at any point in this project, your plan to put any panels in anything that's determined to be a wetland?
No.
So it's my understanding that you will be seeking the county approval of the SUP, and let's just say that will happen tomorrow. Then you have to come back before the county staff to submit the site review permit. How long does that process expect to take or usually take on these
The
projects?
site development permit could take anywhere between 3 and 6 months.
And part of that is
approximately.
because a more extensive wetland delineation?
It is a much more extensive, and that's where actual wetland delineations, field delineated delineations are required.
And if some are found that aren't on this preliminary work and all this that we've seen, how will those be addressed?
We would avoid those wetlands.
You would avoid them. So then all the ones that are delineated, and I think we covered this before, what is the actual plan for those areas?
So we've
There was a
delineated all
management
the,
plan?
we've delineated all the wetlands on the site throughout the site, and we are avoiding those with our panels.
Okay, so with a little bit of knowledge about United States Department of Agriculture, when farmers like myself come in, we have to go through the wetland reviews, and I kept hearing the farm wetlands, but a acronym that we always had was prior converted farm wetlands, which meant we were continue to keep farming them because they were prior converted, what a lot of people like to use the term grandfather. So if there's prior converted farm wetlands that become wetlands you have to eliminate, what is your protocol? Because then I would believe they're going to revert back to meet all 3 criteria. Since they're not being farmed every year, the vegetation is going to reappear. I'm getting a nod from your expert in the back. So that's one thing farmers like me, who absolutely fear the U.S., or not, the Corps of Engineers coming in with some kind of wetland determination saying that we've altered or affected it, that we don't want to ever see happen. What is your management plan for that? Is that going to be allowed to happen?
That's a great question, and I was hoping we would get to that earlier, but I'm glad you're bringing it up. So we're going to avoid all of those wetland features, and through the site development permit, part of that procedure is having a conservation plan through the Soil and Water Conservation District, and they're going to specify what kind of wetland seed mix they want to see put there, so that you meet the vegetation requirement of then that being a true wetland. Or they can say just protect it while you're under construction and let that vegetation naturally come up. And so we'll address, I can't answer it fully right now because that's more of a decision for land use, soil and water conservation district through the conservation plan.
So it's possible that you would manage these wetlands, perhaps improve them, or they're going to let them revert back to wetlands. Or what
Exactly.
but none of them will ever become part of the project site
Correct.
with solar panels or inverters or.
Correct. It's going to be a net plus of wetlands, more high quality wetlands added to the project.
Okay. So if I remember correctly, this is the 5th or 6th solar facility that you're doing connected to a peaker plant? Or 4th or 5th?
This will be the Pride of the Prairie project and the Pride of the Prairie and the Plum Valley projects are our 3rd and 4th projects interconnecting. We also have another project under development as well, connecting at a 5th peaker plant that Earth right
And I
now.
can't remember the name of it, the one south. Is there hydric soils prevalent on any of those other projects?
I didn't manage those projects, so I can't speak, but I would assume that there are hydric soils in limited areas.
At one of those projects, yes, there are.
You said every one of them or?
No, at one of the projects that we're currently working on, there are hydric soils.
That's under development now.
It's construction has started.
Have you done any special structural engineering with the steel, with the pylons that are zinc coated there?
As far as the corrosion aspect of it, no, it wasn't deemed necessary there. The settlement portion of it, which is another aspect of the hydric soils that was brought up, it has necessitated some specific approaches there.
Which I guess would lead to a question I have for Mr. Becker then, because this appears to be one of their main concerns, is possible groundwater contamination. Have you been able to uncover any evidence? I'm assuming in the last 10, 20 years, this seems, from what I've learned, to be a standard practice of driving pylons. And I believe one of the reasons they say is it's way less obtrusive than putting caissons in. It's easier to decommission in the event it wants to be reverted back to farmland. Have you found any evidence or have any documentation that groundwater contamination has been occurring?
Yes, there's numerous articles on this particular topic. The reason that there would be mitigation, if you saw from soil and water studies, we demonstrated the maps that showed red, where soil and water said these were unacceptable, the soil types, because of the high corrosion rate. And yet, if you looked at the rest of the application, there were also maps that were all green. So if they had in fact encased those in concrete, it would be safe to do. But soil and water says it is not safe to do. So yes, there are numerous studies regarding galvanic corrosion. And as Ms. Eager testified, especially when you put these steel posts into hydric soil. And that's why this is so critical. Our area here is so unique because of the glaciers. We are in the headwaters of 3 different creeks. They all go down to the Kankakee and Des Plaines River. If you look at the maps that we provided, there are water resources coming everywhere. Main stems, waters of the U.S., floodplains, wetlands, everything. This is a environmental disaster to put these pylons in here because they are going to leach the zinc and they're going to leach them much quicker, as Ms. Egger testified. This is just, as Soil and Water said, every one of the properties is unsuitable for this particular project. Take this someplace else. You can't put it here because of the soils.
And I'm sorry, just if I could.
I don't think that the type of steel that the pylons are made or whether they're encased in caissons is really under my review. But what I'm specifically looking for is, do we have documentation, say university articles, lawsuits or something where I get that there's going to be corrosion. I put in fence posts in 1999 that, to my shock, 20 years later, I leaned against them and they fell over because they rotted at the ground level.
That's the whole point. Exactly.
So have we documented, though, that there's been contamination in groundwater? Do you have any of those sources? And that's not even probably up to my,
There
review,
are-
but that's something I would expect that you'll be bringing up if you take this into a legal challenge.
Yeah. Well, we have several articles, laboratory and field corrosion investigation of galvanized utility poles. So there's multiple articles.
But we're talking about the corrosion, but so it's my understanding they've changed zinc coating or the galvanized steel greatly in my lifetime. I can find galvanized steel from the 1930s that has no rust in it because it's got a high concentration of lead. And the EPA and other sources said that was highly terrible and was leaching into the ground. And we've removed the lead, which has technically made the zinc chromated galvanizing a lot less effective. I bought zinc chromated nails that were rusting in the box, brand new.
Well, that shows
What
you
I'm
how,
looking for is there documentation that this is contaminating soil in some other solar facilities. Do you have that to present to me? Or
I am not aware that there's a solar facility like this that is in this type of hydric
Okay.
soil. So you're taking a massive risk if you vote in favor of this. This could poison the soil. It could destroy it for agricultural purposes in the future. And it gets in the groundwater. It's going to leach into the wells and it's going to poison people. And because of these Forked Creek and Hickory Creek and Prairie Creek, these are waters of the US. And if this leaches into the groundwater, it gets into these waters of the US, and that is in violation of federal law. This is extremely serious. We should not risk our health with this project.
you might be right on that. But once again, I got to go back to my review of what I'm allowed to make my determination on. And the last couple of days, I've been thinking about this, and in all the trainings I've done on these programs, it's about findings of fact. So I thought I could come back to one of the findings of fact we're supposed to look at is endanger the health of the public and other things. And I was completely waylaid because when I go to the staff report, special use permit, the staff findings, it says even here, due to the recent solar case, the special use permit criteria are not applicable to commercial and solar facilities. So our land use staff, I don't think they did this on their own, they're probably directed to, did not even break down the findings of fact and criteria for the special use permit. They did do all that for the variances, whether or not it would endanger the public health, change the locality and such as that. So
I understand that. I can respond to your question that the problem with the advice you got is it's simply wrong. The equity solar decision versus Grundy is a very limited decision. It doesn't force the board to go ahead and vote just because they file an application. Grundy was very limited to the narrow facts of the case. Judge Anderson wrote in there that that was a case that dealt specifically where both parties agreed that the applications were fully complete. We completely oppose that position here. We put testimony on, and we obtained testimony from the other side that they didn't do any farmed wetlands during this time period. They didn't leave any of the land fallow, and they said they were all being farmed during that time period. So their application is completely incomplete. If you read the county solar statute, there is a direct requirement that they must delineate all wetlands. That is a requirement for their application to be complete. They admitted here they haven't looked at any farm wetlands because these were all being farmed. Like you said, you were a farmer, you knew about it. What happens is when you stop the farming, then you have to look for the hydrophytic vegetation. They have not done this. This application is woefully incomplete. And you always have a right as a board, irrespective of the court decision in equity solar. If the application is incomplete, you have every right as a board to deny it. And you certainly have a right and a responsibility when this is going to put the public safety at risk. That is a due process violation.
So once again, you may be right. So what I keep looking for is what in the county findings of fact I can turn, because as one of my fellow commissioners mentioned before, my scope of what I'm supposed to review, and I'm assuming as a lawyer, you know this on this commission, is much narrower than a county board member. I have to go with the county land resource management plan or the zoning code, which I tried to come back to. Are there a number of residences too close to any solar panels? Some of the other things that even might pertain to our old zoning code before the state law kind of usurped local zoning codes.
So one of
And
the,
so obviously we know how my vote was before. I'm looking for the evidence that I can use to flip that from before. And I've been advised, we are not the final say, we're just a recommendation. Just give the people what they want and vote no. So I've had to put a lot of egg on my face to try to stay with what I've been trained to do and do here and not go the easy route. So I'm still trying to, oh, and here's one of the areas I want to attack then. In these proceedings before, we've come up with a LISA score over 220, of 225 and above. And I've been told that there's an obscure state law that prohibits development of land with a LISA score over 225. Are you aware or can expand on that? Because I don't have the legal basis to do that.
I believe we cited it in the questions, yes.
Okay, you did, but then you sort of tied in there, if I understood it correctly, federal dollars. Does that mean it can happen if there's no federal state dollars applied?
I think you'd still be prohibited based on the state law.
So that is a law that I'm kind of surprised has not ever come up to any of our cases, because we've had more than a few cases in the 8 years I've been on this commission that had a LISA score over 225. And once again, though, I think that may be out of my review here. I can't make these legal determinations. I'm specifically looking. But if somebody was to come up here and say, we have legal precedent that this case or this case, you know, people versus whatever, was overturned because of a LISA score over 225. You can't provide that to me right now, though, can you?
Well, we did provide the information to you. The reason you haven't heard this before is for some reason in this county, there's not been any cross-examination for years during a special use application. That's what we won in front of Judge Breslin, is the fact that apparently Will County had an illegal policy and practice, at least going back 7 years, not allowing any cross-examination in these special use applications. We are apparently the first one who has done this in all these years. That's why you haven't heard this before, because this is a new procedure that was apparently being bypassed by Will County. Unbeknownst to me, I don't know how this has happened and how it was approved, but Judge Breslin clearly ruled in our favor that this was an illegal violation of due process. So this is why we put on testimony for you tonight, especially from Ms. Eggers, talking about the public health risk that happens from this type of putting of these steel galvanized posts into the soil and how it can leach into the water. And we did cite the information about the LISA score to you. That's why you haven't heard this before, because no one apparently has done cross-examination until we decided to sue and win a temporary restraining order. So that's the reason why you should do this.
Do I take her legal testimony to be impertinent to the land use special use permit when I know that the county has staff, and I assume engineers, that reviews all this? Because once again, our scope here is the zoning. And therefore, there's many things before they do the site development permit, more check boxes they have to check. I am correct here. There would be a lot more you have to do. And there's a lot of those things that you probably don't do until you get the special use permit because they're expensive.
That's part of the reason, yes. Mhm.
And we've heard numbers of 1 billion or whatever. I'm assuming throughout this process, 3 special meetings, multiple officers, multiple staff times, multiple reports, you're into this for millions of dollars already.
I don't know the answer to
You
that
won't,
question.
you won't tell.
Well, I'm just a lawyer. They pay me by the hour, but I do want to address a couple of your questions. I think they were good ones. And the article quoted by or cited by Mr. Becker just now, for the record, Judge Breslin ordered that to the extent any evidence were to be entered today, documentary evidence, that it would be exchanged between the parties by Friday at noon. That was her order. That was fair. That was something we actually agreed on. That's why I sent our wetlands supplemental delineation report to council on Friday morning, and that's why he sent documents to us on Friday. So they're barred by the court to enter any documentary evidence today, but nevertheless, that article that he cited is from the American Galvanizers Association. We're familiar with it. It says nothing about leaching into groundwater. It just doesn't hold that whatsoever. There is no evidence of, or documented evidence of steel piles from solar facilities leaching into the groundwater. It doesn't exist. If it did, you would have heard about it, and it doesn't. Ms. Eager testified as to her specialty, and she certainly has a lot of experience, but she also said, words from her mouth, she's not a galvanized steel expert. We brought an environmental scientist with a PhD to you and testified on this very issue because we wanted to make sure that it was addressed. We had heard that it was, a concern. We wanted to make sure we got the best expert on it that could come to you and explain to you exactly what it meant and why it wasn't a concern. And that was Dr. Olson. That's who we brought to testify, and he provided that background based on his expertise. The question that what they're asking you to do, they're asking you to vote to recommend denial on a permit for reasons that are completely outside the scope of your review, either under your solar ordinance, under 55 ILCS 5/5-12020, which is the citing law, and under equity solar, which is the case that keeps being cited. And just so we're clear, equity solar was not a limited decision. Equity solar was the decision that the state has been looking for until equity solar came out in March of 2026. There was a question as to whether any county in the state had discretion to review factors outside those that are set forth in the citing law 5/12020. Equity solar answered that definitively. Counties do not have that discretion. Now, that does not mean that we have not tried to honor the county's ordinance here. The county's ordinance has all sorts of stuff in it that are outside the standards allowed by the citing law. This application was developed pre-equity solar. It was developed in conformance with the existing county's solar ordinance, which hasn't changed. And it was designed to honor the county's way of business. And we believe that we have done that. That includes delineating all wetlands that are required at the time of the application, which we testified were all those wetlands from the very credible federal government U.S. Fish and Wildlife Service data set. That's what we had. That's what everybody in the industry uses. And it was testified that, professionals in the industry use that exactly. Then, because there was time, because Mr. Becker sued the project and we were remanded back, the field delineations were completed within that time. So as a cherry on top, we brought you the supplemental report that now shows all wetlands, including farmed wetlands, delineated in the supplemental report, which serves as effectively an overlay on the site plan. So we now have all wetlands delineated, and you heard it from the horse's mouth. They're going to avoid them. They're going to assume the jurisdiction of the wetland, and they're going to avoid them all. And so that's really important. That eliminates the wetland as an issue entirely. That's by design, because we didn't want to have this argument. We wanted to just avoid the wetlands and avoid the argument altogether. Plus, it turns out to be a net positive on wetlands for the county, and the company felt that was positive. So the galvanized steel issue doesn't exist. There's been decades and decades and decades of galvanized steel in the soil, and there are no studies that show that it causes any serious public health risk as suggested by Mr. Becker, or any public health risk as suggested by Dr. Olson, PhD environmental scientist. So we had hoped that had put that to bed. We knew that these questions would be asked. We prepared for them, and we believe that now we've addressed those concerns that Mr. Becker brought up, and hopefully we've answered your questions too. But we're happy to continue the discussion if you have additional questions.
I have a question.
Yes, ma'am.
First of all, what's your oldest solar facility you have operating right now? How old is it?
The solar facility that's operating
That are currently
was commissioned
operating.
this year.
Pardon?
The solar facility that we have that's operating was commissioned this year.
This is the first one you've got operating this year?
That's correct.
Earthrise as a company, yeah.
Yes.
Oh, so you don't have any, so you wouldn't be able to go and test soil that you've had these on, or do you plan on testing soil around these at any future time?
We don't have any reason to think that's necessary.
Even with all these questions about the,
We've
So if you have
reviewed
any-
the issue very thoroughly, and we don't believe there's any evidence to suggest that our construction methods pose a risk to public health or agriculture.
Yeah, the issue is not new, and solar, having been developed for decades is not new, but the issue of galvanized steel has been studied, since the 50s. I mean, there's an article that balances, the risk of galvanized steel in the soil and finds no risk. So, we didn't feel the need to bring that literature because we brought the live testimony, but it just, it hasn't been an issue. This is not new engineering science.
Okay, you don't know that it would be an issue or not, but my other question
Okay,
is,
that's true.
why so many acres?
Well, I'll turn to Mr. Cabas.
Well, the acreage is to support a facility of a specific, of a target capacity. Our target capacity for this facility was 600 megawatts, which is in line with the peaking facility. I think I mentioned in previous testimony that we utilize surplus capacity. We basically use the available transmission capacity on the power lines to interconnect. And so when we develop a facility, we develop it based on that target capacity, and it requires a certain amount of acreage to support enough solar panels to produce power at that desired output.
So you have to have that all checkerboarded over the area? It's not concentrated?
We need a sufficient project footprint to develop to that target capacity.
Well, let me expand on our question then. So I know where the Lincoln peaker plant is.
Yes.
So I guess to make it simple, if the 1.5 mile radius of that plant, you had all willing landowners to rent to you, you would have preferred to put it all within that 1.5 miles?
An ideal footprint would be a circle with an area equivalent to.
And so why didn't you do that?
Because when we evaluate a site, we're evaluating a number of factors. We're looking at environmental constraints, we're looking at title constraints, we're looking for willing landowners who are willing to transact, but there are a range of factors. And so our footprint represents an optimization of all those variables that we take into consideration.
So it's safe to say there's a number of people you approached with this project and they said no.
Yes.
Thank you.
Well, I took over on you.
No,
but,
good.
So the chairman wants me to, yeah, but I have a couple more. So the leases,
Yeah.
can you tell me how many of the leases control clause or have a clause in them that would allow the possibility of a battery energy storage system?
Our form lease, our leases vary a little bit. There's specific bespoke terms in each, but our form lease does include that.
So pretty much every lease you present to a landowner probably has it unless they ask you to remove it or their lawyer when they review it.
Yes, that's correct.
And then it's also come to my attention that you own some of this land of the 6,099.
We own
A subsidiary of Earthrise owns some of it.
we own a small percentage of the land. Most of the land is being leased back from the actual owners of the property.
Small percentage, single digits, less than 10%.
By the
Less than
time that the
30.
project is developed, Earthrise will lease, I'd say, over 90% of the acreage.
Lease.
Lease.
Yeah, but how much do you own?
I'm sorry. By the time the project is constructed, Earthrise will lease over 90% of the land.
So I'll go back to her capacity question. Your capacity of 600 megawatts is capped by the interconnection agreement.
That's correct.
And I've spoke several times at these cases that we've had several speakers and it's been confirmed that over the course of 6 years, this person said in their business, they had seen the photovoltaic panels increase in efficiency. I believe his number was about 40%. So if you're needing 6,099 acres right now to make 600 megawatts, and new technology comes online, and say 5 years from now, you all of a sudden have the capacity or are producing 800 megawatts, what happens to the 200 that you produce? Can you not sell it? Is it just lost?
We would, in order to inject more power into the bulk transmission system, we would need to go back and seek another interconnection agreement.
Is that something you would do, or would you consider removing some of the land from the project and decommissioning some within 5 or 10 years?
I think that determination will have to be made at a later date.
It's also a constraint at the peaker plant. So, right, so
ultimately, our business model is to use available surplus transmission capacity at these peaking facilities. That's our business model. That's our strategy. That's how we go out into the market. It's our competitive advantage. And so to do anything different from that would really be deviate from our core strategy.
Right, and if what I understand all these proposals, the interconnection agreement is a significant portion of the infrastructure investment. And you already have that, so you basically are sidestepping that additional expense of the interconnection with ComEd. You would just have to be interconnecting to the peaker plant, and you'd be doing that with your own contractors and outs. That's the way I understand this project, correct?
I don't think I'm following your question.
So all the solar cases that I've heard
Yes.
require an interconnection agreement with ComEd. And ComEd to usually do the upgrades. In a recent case, they were coming almost 2 miles with a infrastructure improvement. And I know we had a large one in southern Will County that the project was pulled before it was heard by the county board after this commission had heard it, because as the newspaper article said, their interconnection agreement estimate from ComEd had gone from 30 million to 50 million.
Right.
I mean, and so obviously the applicant, or the way they portrayed it, the applicant decided that extra $20 million cost was a deal breaker. And you don't have that cost per se with ComEd.
That's correct. We do not have that and that cost, we don't have that cost because we're connecting through a different pathway. They're interconnecting through what's called the queue. And so basically that's the typical way of doing it if you don't have a natural gas peaking plant available to interconnect at. And so by utilizing that infrastructure, we do not have to interconnect through the queue. It's a separate process. It's a different process of interconnecting. And so we do that. Available transmission capacity is already allocated to the peaker plant, whereas our competitor interconnecting through the queue has to analyze the impact to the bigger system and has to determine if there is available transmission capacity. If there's not, then they have to pay to upgrade the system to accommodate that additional generation.
And if I remember your testimony before, there is a time limit on that peaker plant. It will sunset and have to cease operation at a certain time.
That's correct.
What date is that?
For the Manhattan facility, I believe that is over 10 years out.
So the peaker plant would be shutting down long before the life expectancy of the solar facility.
Under the current law, I believe that is correct.
Okay, so it's not your decision to shut down the peaker plant. It's because of the CEJA, rules of the CEJA.
It's not our decision. No, we're bound by law.
So that could actually change.
That could actually change. That's correct. That would have to be determined in Springfield, but not by Earthrise.
At that point, would you have to connect with ComEd?
I'm sorry?
At that point, would you have to connect with ComEd once the peaker plant shuts down?
To be clear, the governing body who determines our interconnection is not ComEd. I think you're probably familiar with the distributed generation, the community solar projects, the smaller, 40-acre typical projects. Those are connecting to the distribution layer of the grid, the poles and wires that deliver power to homes and businesses. We're connecting at the transmission layer of the grid. And so at the transmission of the layer of the grid, the governing body is PJM. And so that's who we're working with. So I just wanted to clarify that.
Their Manhattan peaker plant is directly across the street from the Manhattan substation for Commonwealth Edison. And I saw them build the new line in there. It's a lot different than what you would see going down the road. It's a high voltage transmission.
It's a high voltage, that's right.
And for your benefit and the benefit of the people here, I pulled into the peaker plant the other day. There's a gate there, like you said, and I hit the button. Was going to ask them if I needed to get a hold of somebody, would they be able to do that? They opened the gate. So your facility is?
Told you there's a door to knock on.
I confirmed what you said.
Yeah.
They opened the gate and then she was confused as to what I was wanting to ask her, but she said, yes, you could come up to the office.
I'm delighted to hear that.
All the people here, if you want to go talk to somebody at the peaker plant in the future, that opportunity is there. But I know you're going to be asking for best probably later in the future because our thirst for electricity is not ending. or at least I should say, I very fully suspect you'll be asking for battery energy storage systems in the future.
Somebody
with this-
probably will, whether it's Earthrise or not, we don't know. But if Earthrise did, for certain, they would have to come back to this board with another special use permit application, at least as your ordinance is currently written, and ask for that permission in a hearing just like this all over again.
And if I could, I'd just like to make one final point since Mr. Jacoby had quite some time to talk. You had asked about if there is a reason that you can deny the application. We asked numerous questions tonight about the solar arrays. One of the requirements in the county solar statute is that the applicant is required to list the exact number of solar arrays. They testified tonight here, they don't even know what arrays they're going to use and that they didn't have any numbers in their application. So that gives you a perfect reason to deny this application, vote no, because the application is incomplete.
The number, I'm sorry. That is a false statement.
Once again, that's something I couldn't determine. I guess I would have to defer to the land use staff, and the land use employee that actually filled out this application is no longer with the county, but
I'll make it real easy for you. Those numbers are on the site plan on every page of the proposed condition use in a site data table. So those numbers are right there. That was requested by the land use department to make our application complete, and that was complied with on March 5, 2026. So that is not a valid reason to deny the application.
I directly dispute that. I asked them specifically about the number of racks, and they said they don't know, and they don't even know what they're going to use. If that is what is required by the statute and they don't have the numbers in, then you have to deny this application because the application is incomplete. It doesn't matter what land use says, if they advance it. It's your job as the commission to do the right thing. And if the application is incomplete, you need to deny it.
There's nothing in this ordinance that requires a number of racks.
Yes, there is.
No.
I'm going to have to shut up now because I believe we're under court order to finish this meeting in 3 hours, and it's my fault that we've gone over. So
you can blame it on me too. So what percentage of this project is going to be on hydric soil? Is it, what percentage of this project is going to be on hydric soil?
Based on the report, about a third.
About a third of it, so 100,000 posts. So, and I'm just trying to understand it because there is no cases, or literature that are directly cited, but is there no literature or cases pointing to contamination of soil or groundwater due to the lack of similar projects with the density of posts in the hydric soils?
I want to clarify my previous response to your question.
Okay.
So that measurement of approximately 2,000, I think it was 2135 was the number I saw in the report. That refers to the entire parcel. That does not necessarily mean the area under the panels.
oh, that's right. So 6,099 acres is a parcel. How many acres do you know
Understood.
you need to make 600 megawatts?
How many, you're asking the number of acres under panels?
Photos.
I can't give you a final, an exact number on that, but it's obviously going to be less than
But as
6,000.
this time, it's not your intention to avoid hydric soils where you put the panels. You'll be avoiding wetlands probably, but not, it's not your intention to avoid hydric soils.
That's accurate.
That's accurate.
So there's not been any studies on a density of galvanized posts in hydric soils similar to this project?
As I testified, we don't believe that galvanized steel is a threat to public safety or agriculture.
Understood. I'm just more of a,
He's making a point because you're probably using the same exact steel pylons as the highway department uses at every guardrail.
I don't know what the highway department uses, but I will note that, there is abundant galvanized steel farm infrastructure throughout Will County. There's some very large grain elevators all over Will County that are made out of galvanized steel. They're exposed to
Thank you.
rainwater with a lower pH.
Off the rails.
One speaker at a time, and the speakers are at the podiums. Thank you.
I'm good.
Okay. Marguerite, may I ask you a question?
Sure.
In the information we have here to vote tonight, we don't have the four original
Conditions. We'll need them up on the board.
conditions. Did we get the conditions put up on the board or someplace where we could see them?
Yes, with the original presentation or the first presentation slide deck, slides 4 and 5, I believe, have the conditions. I think slide 5.
You didn't tell us to bring our old paperwork.
I don't think any of us understood you. I'm sorry.
The other slide deck, if you would.
Just a disaster. Should we get that many?
This is our new information here.
Some of the. They wanted to change some.
Yeah, they had this project is approved for the CAD wiring system. That the fire routes be gravel. And the road use agreement, and he wanted to add consistent with the Will County ordinance. But there's no way one of us can recite what these conditions are for the record without something written in front of us to look at. I've just used paraphrasing here. That we're going to need a great amount of help. And I believe the chairman's wanting his commissions to be added before we can have a vote.
We'll get the presentation pulled up shortly.
Okay.
Which running the show?
I did at least find my notes. It's not complete.
Why weren't those cases handed on ahead of
Yeah,
time?
we're gonna get paid.
They want to change.
Well, I addressed the road use agreements and they said they won't give them out
This is.
until, they won't give out the permit until the road use agreements are in place, but now they want it as a condition. If you remember, I wanted to add as a condition, they said it would be redundant.
So the conditions on the screen are what was recommended and read by the Land Use and Development Committee. You heard tonight the developer requesting condition number 3, 5, and 6 be also amended further. So I think the way to go about would be amend condition 3 and then adopt 5 and 6 as the developer has stipulated.
And number 3 was the wording similar to the project is approved using the CAD wiring system that's in the application. Is
Provided,
that sufficient enough?
provided, however, that the project's approved to utilize cab above ground cabling system between panels as described by the applicant at hearing.
Are we okay to use that wording legally?
That's what the county board approved for Plum Valley.
And then condition 5 to add the wording that,
Condition 5 was a little more involved. The proposal was notwithstanding any other provision in the Will County Code, including Chapter 164 of the Will County Code, which is the site development permit chapter. The fire lanes, including access roads, shall be gravel per the request of the fire departments. Any such gravel fire lanes shall be considered pervious under the Will County Code.
okay, and that is consistent with what was approved at Plum Valley.
That's exactly what was approved.
That's the way, okay.
Yep.
And then number 6 was the road use agreement. You wanted to add the sentence consistent with the Will County ordinance at the end of what this says?
That's right, because it's duplicative of the ordinance. And so we just added consistent with the Will County ordinance at the end, comma, consistent with the Will County ordinance.
Okay, so, Mr. Chairman, I'm going to make a motion as soon as concerning ZC 25-129, special use permit 25-056, that the staff conditions be modified as stated for number 3, 5, and 6. And I will forego trying to read them, the ones that were stated here and understood. That's my motion.
So we have a motion by John Kiefner.
Second.
I have a motion, a second. May I have a roll call, please?
And these are to amend number 3, 5, and 6.
Correct.
John Kiefner,
Yes.
Matt Garland,
I'm sorry, this is just for the amendment to the
Yeah,
conditions?
it's for the amendment.
Yes.
Louis Navarette,
Yes.
Karen Warwick,
Yes.
and Chairman Hugh Stippen.
Yes.
And that passes for the amended conditions. 3, 5, and 6 will be amended.
Yep. Mr. Chairman, ZC 25-129, special use permit 25-056. Approval of a special use permit for a commercial solar energy facility with the 6 conditions as amended. Am I saying that right?
Yes.
Okay.
Second,
Second.
Louis Navarette, second motion. John Kiefner,
No.
Matt Garland,
No.
Louis Navarette,
Yes.
Karen Warwick,
No.
and Hugh Stippen.
No.
1 to 4.
We have to do a motion for adjournment.
Well, thank you.
County building.
Public hearing session.
Yes.
And Commissioner, you have the board right now. Do you have the mic for public comment?
There's the mic for public comments.
Yeah. Have we anyone who cares to make public comment? Now, you can't affect the vote because the vote's over, but you're welcome to, yes, sir. Come forward.
I was hoping many people would leave before he said that.
Why are they going to comment?
I told my wife I'd be home by 10.
Yes. fine.
You will be. You will be. It's
I may not be. I believe our public comments limited, Mr. Chairman?
This won't take long.
15 seconds.
Okay, my name's Jim Baltus. I live in Manhattan Township. I want to say that I have confidence in this board and any other boards that you consider future solar projects. I know you will follow Illinois law and the proper process. For projects like this, that means a few basic things: a complete application, proper public notice and a fair hearing, review of local plans and ordinances, consideration of the roads, drainage, and nearby properties. And then also, I want written findings of fact explaining the decision based on the evidence. These steps will help everyone understand how and why a decision is made and how they protect the county and the public. I request that this be made part of the record. And one little side note, I'm the road commissioner. I built the bridge on Baker Road. I did this with federal funding. It was stated here tonight that they can start the project And if they find an owl, then they have to stop. Well, with this project that I had the short-eared bat in my area, and I had to go through so many steps to make sure that this short-eared bat was not affected in this project. All right, so my question is, how come there's two sets of rules? That's
State legislator voted them in. We know that, don't we?
all right, I know that. But you know what? I'm doing a job to protect the public.
Yeah.
Okay, so here's the deal. If you're going to have rules, we got to have rules for everybody, not get started and stop. That's all I got to say. Thank you. Do you want a copy of this?
Yeah, please, for our records. I thank you very much.
Thank you for your time. Thank you. Thanks for coming out.
Yeah,
There you are.
yeah, we appreciate it. Thank you.
Hi, I'm Laura Heydrich. I've been here before. My problem with the whole special use permit process here has been, we had to do a special use permit to have more than 5 adult dogs on our property, okay? We had to notify all the adjacent property owners before we made the application. This application was made in November last year. We didn't get notified by mail or anything else until, what was it, March? Long time. So how can that application possibly be complete? Because they didn't notify any adjacent property owners in time. And the other thing that I would say is that they're trying to say that these panels aren't going to be by our house, but they are, and they can change their mind about what they want to do, where they want to put the panels after they get this special use permit. Once they get the permit, they can do whatever they want. They come back to you, but it doesn't stop. They can say anything they want here. And that's what I have a problem with. I mean, when I made my special use permit, I had to say how many dogs I wanted that special use permit for. And it wasn't open-ended. They didn't say, oh, let us know someday. And I just think that if you're going to treat normal people that come before you one way, multi-billion-dollar corporations should not be treated any differently.
That's why they got voted down tonight.
I appreciate your vote. Thank you so much.
I would only add that it's a very beautiful, very benign term, but in reality, it amounts to a solar desert, I believe. And I think a lot of people think the same thing. So I think it's just important to think about what the impact of this is going to be on a lot of people. And we would appreciate your support. Thank you.
Oh, and all of our farmland all around us, they are going to own all of that all around us. So any of those pilings are going to be putting stuff into our well, all the way around, 1,000 acres around us. So, and all you got to do is Google it. I mean, we saw 3 different studies just in 5 minutes. So I don't know how they can say that it's not going to affect anybody, and it's going to affect us a lot.
Thank you.
Hi again.
Hello there.
Melissa
You
Eager.
finally got to get your say in, right?
I know, thank you. So listen, I have comments prepared, but all I want to say is this instead. I'm going to acknowledge that their experts said there's minimal leaching from zinc. Minimal over thousands of acres and tens of thousands of poles becomes substantial. And I want to put this aside and just say to all of you today, thank you for hearing all of our concerns, hearing what we have to say, and protecting our potable water where we're all on wells. And I commend you all for making the right decision today, and thank you. That's it. Thank you.
Hello, my name is Larry Kolash. I'm a Will County resident of 30 years, veteran, search and rescue volunteer. And I'd like to say thank you for giving your considerations for these, and I hope you keep an open mind. In the future, there's going to be other opportunities that are proposed, and with regard to solar energy. As you can see around you, that we've shut down our coal power plants. The Will County Generation Plant in Romeoville used to generate 590 megawatts. It's gone now. It was closed down in 2022. It used to be a landmark You could see the plume for miles around. That was injecting sulfur dioxide at a rate of 10,000 tons per year. So let's not forget the results. This is why we're transitioning. We're moving off of that. It used to generate the result in acid rain, severe respiratory issues, asthma, lung disease, as well as the carbon dioxide, 12.5 million tons per year. There's another plant in Joliet, or south of Joliet. It's pretty much the same thing. That one shut down too. In its wake, there are 3 million tons of poisonous ash left behind, leaching arsenic into the groundwater. The Lincoln Stone Quarry cleanup cannot fix it, according to the EPA. They just determined that. So my advice is don't drink the well water in Joliet until the 2030, when the Lake Michigan Water Project is complete and you actually get clean water off of Lake Michigan. It may be too late for Joliet, but maybe not for the rest of us. I think it's important to evaluate the impact on the land, but also by comparison, you've got a disaster cleanup here with the coal plants, and we'll never be able, it will be really hard to get rid of those. People are asking for affordable, clean energy now. Where's it going to come from? We've got to decide where that land is and put it in. I don't think there's any holding back. State of Illinois wants it. We've got 27 million acres of farmland, and less than 1% of it is used for solar. So, I mean, 1/1000th of it is used for solar. So you have 1,000 times more for farming. And so I commend you. I think it's important you protect us. It's also important that you help us find that future of transition. Thank you.
Thank you for your testimony.
Good evening. My name is Kelly Baltus. I am the clerk with Manhattan Township. I'd like to share a letter that we have shared with the county board members several weeks ago. Dear county board members, we respectfully request that you postpone your decision on zoning case ZC 25-129, the Pride of the Prairie project, until a trailer bill can be drafted and considered by state legislators to restore local control, consistent with the resolution recently approved by the county board. A brief delay, especially in light of Judge Bronzland's temporary restraining order due to Earthrise incomplete special use application, would allow for a more balanced and collective approach to an issue with long-term consequences for our county. We are not opposed to solar energy. We are opposed to large-scale industrial projects of this magnitude and are simply asking for reasonable local control. Senate Bill 25 has limited the ability of counties and townships to uphold comprehensive plans, community standards, and long-standing land use protections. As a result, local governments have been unable to ensure that developers like Earthrise work in true partnership with our communities. The accelerated special use process has further reduced opportunities for meaningful dialogue. SB 25 was not crafted with local communities in mind, but with the interest of large profit-driven entities. This makes it all the more important that we work together quickly and constructively to pursue a trailer bill that restores local authority and better protection of our residents. We understand that postponing the vote may affect incentives available to Earthrise. However, those incentives are funded by Illinois taxpayers and could contribute to a broader state budget challenge. Those dollars should support our local communities to attract and retain residents, not allow negative physical and visual impacts that will remain for decades. As County Executive Jennifer Bertino-Tarrant was quoted saying, "It is a flawed process." We share her concern and we hope you do as well. A short delay is not a rejection of process. It is a commitment to getting things right. It allows for better alignment, stronger collaboration, and more responsible outcome for our county. And I do want to point out, since we've sent this letter, State Representative DeLuca has already introduced several House bills to restore control of local government. This is happening quickly. We need to take our time and be thoughtful about it. Thank you.
Thank you.
Hello again, my name is Alexis Snow. I want to thank each and every one of the board members for being professional, not making silly faces, not chuckling and other things, because I've noticed that today in the room outside of just the general public, other professionals, so to speak, not necessarily naming Earthrise either. Just a couple things. They've only had one solar facility be around a year, operating for a year. So we don't really know what these posts do in the ground. They need to be there for a while for that. Their experts are ones that they chose, not impartial experts. And why aren't these all being considered individually? Every other one is individual. Why is this one being considered as a lump sum? Thank you.
Thank you. Thanks for your testimony.
Tim Shanahan from Manhattan Township, and I'd like to thank you for listening to 4 hours of testimony and making the right decision. You know, when the meeting first started, I had heard Earthrise say that the reason that they're choosing the Pride of the Prairie location is because of the cogen plant. So I have a business plan for Earthwise. Why don't you go ahead and find suitable solar land and build a peaker station at that point and save yourself a lot of trouble? But thanks again for the vote.
Thank you.
I also want to thank you for the vote, Jeff Becker from the Watershed Committee. The Watershed Committee is a volunteer organization. You don't know how many experts and paid consultants have told residential residents, there is not a wetland here. There is not a farmed wetland here. And we then come and we go to the Army Corps or the IDNR, and then all of a sudden it changes and it is there. The paid consultants are here to sell you a project. We are just a volunteer organization that fights to protect the environment. And you have to have hydrophytic vegetation. When you farm and till a field, you cannot determine the plants that are coming up. That's why it's between April and October that you have to allow those plants to then show themselves. It makes perfect sense in how everything works for planting. If a field is being tilled, you cannot determine hydrophytic vegetation. You have to wait until it is fallow. And I think that is something that they're missing in the U.S. Fish and Wildlife Service. They have a wonderful map. It's an inventory, but it's delineated mainly wetlands. It's not all the farmed wetlands. And we've had project after project that we have been brought onto where there was either a floodplain or a wetland that was not identified, and then it required protection. So that is a situation that has to be protected because there's only 10% of the wetlands left in Illinois. So we thank you for your vote. We really do appreciate it. Thank you.
Thank you for your testimony.
Hello, my name's Gary Schweers. I live on Schoolhouse Road. I am affected. I'm going to be surrounded on 3 sides by the project. My property also butts up against the wetlands. We have a lot of migratory birds. We have deer that run through there. And I'm just concerned how all that's going to be affecting, the wildlife and our lifestyle. We've been there 38 years. So this has come as a complete shock to us. This is my first meeting that I've attended. I too am a operating engineer. I've worked on many a Superfund site over my years. I know what leachate is. I know what it does to the soils. I know how it travels. My concern is everybody's talking about surface. I'm curious to know, does Earthrise know that in Will County, again, I've turned a lot of dirt in Will County, and there are many field tiles that run throughout all this farmland to the point where nobody knows where they go. Okay? So it's not just surface. It's the aquifer, it's also these field tiles. Earthrise is in its infancy, if you will. You said you've been operating for a year. I mean, I just don't see where that gives me any comfort level with respect to leaching from these posts. You can Google galvanized posts. I'm sure you're experts. You know, again, they're your experts. They're not ours. Okay. So I just want to thank the board for your decision this evening. I know I have good faith in what your decisions will be in the future. And the only thing I can say is, if this does pass, you can bet that battery storage is not too far down the road. And I would ask anybody that's in favor of this, would you have different feelings if it affected you or if it was surrounding you on 3 sides of your property? Thank you for your time. I appreciate it.
Thank you, sir.
My name is Randy Juris, currently living in Lockport, used to live at Homer Glen. And for better than a quarter of a century now, I've watched Will County develop. And what's going to happen is this land that we're talking about here would like to be kept open spaces, would like to be kept, if not farmland, open spaces. But that's going to take legislation to do. What you guys are supposed to do is to figure out what development you want to see. Now, I've watched the people get stonewalled down at North Point. Nobody really was excited about Center Point. When John Grueling was in power, he turned around and said, this part of the country is going to be transportation, period. So if you don't have solar, what are you going to get? What else are you going to like? You guys cannot legislate that that land's going to stay open land. It's going to stay farmland or open spaces. So what are you going to allow? Turbines, diesels, what other infrastructure to support the data center that's coming? And other data centers that are going to come. I agree that you can try to keep this what you like it to be, but you need to be thinking about what it's going to be. And if you don't like solar, what do you like? I wish you guys would think a lot about it. I know they brought up a lot of things, and I wish that a lot of these things would have been brought up when, we'll say, the data centers came up. You can go to the people in Aurora that are now up in arms about what happened when they did not ask those questions. They're now stuck with a data center. Right now, you've got open land. What can you guys do, or more importantly, the whole board, to keep it that way? Thank you.
Thank you.
Hello, my name is Gary Lincoln. I reside in Green Garden Township. I've been up here before, as many of you know. I think I'm trying to figure out what went wrong in this whole system. And I know that the county board has a lobbyist, or at least I understand they do, in Springfield that kind of keeps them up to date on stuff. I don't understand if and it's not really directed at the board, but it's directed at the state's attorney. If we have a state's attorney in Will County that actually works for us, the people, maybe that state's attorney could go to Springfield, or not. They could go to federal court and sue the governor in the state of Illinois for taking our rights away. Somebody has to do that. And I'm thinking, if we have a state's attorney already on the payroll, maybe that would be something to do instead of sitting there and mumbling every so often when there's a question. Well, you should probably let that go because, they can sue us. No, actually do something. Be proactive for us. That's what I want. I want to thank the board for what they did tonight. I know it was a difficult decision, but I think all of you understand. You understand your jobs. You also understand that you work for the people. You might get a check from the county, but the thing is, you're supposed to be working for the people. And I think you did that tonight, and I want to thank you.
Thank you for your comments.
Good evening. My name's Tim Callis. I am the absolute dumbest guy in this room. Heard a lot of people talk tonight about caissons and galvanized posts. I'm so dumb, I worked on a caisson project in the city of Chicago. We went down hundreds of feet and we used rebar and concrete. She's absolutely right. That's what you use. Second of all, that went on top of 68-story high rise. Multiple times I did that working for McHugh Construction. Second of all, I worked for contractors installing guardrail, which is made out of galvanized steel. And anywhere you go in Will County, who has installed, Department of Transportation, Will County has installed more galvanized than a solar farm ever would if you go way back. So I understand what you're saying about the leaching, and those are, if you drive around, they're probably right along your wetlands. And what are they doing? Leaching in, if that's the case. But like I said, I'm the dumbest guy in the room. I'm so dumb, 30 years ago, I joined a union to work on these projects. And 30 years ago, I never pictured myself where I would be today. And work at this project or any other project that comes around, good, hardworking people work on it. And I commend you for hearing everybody tonight. But think about what people say about a certain specific thing to sway your vote when your own county installs these things along there and the Illinois Department of Transportation that. Just move forward, open your eyes and think. Like I said, I'm the absolute dumbest guy in this room. I'm so dumb I made myself into a field rep organizer for this local in that. So just think about that. I'm pretty dumb. But open your eyes to the big picture, all that stuff. And that. That's all. Thank you. Have a
Just
good
saying
evening.
you're the dumbest guy in the room over and over again doesn't prove it. Made me laugh.
Well, hopefully I don't prove it. My name is Patrick Hosty and I'm Director of Chicago Area Lesset. We represent over 1,400 contractors and 20,000 laborers in northeastern Illinois, including Will County. Despite the decision made today, we don't agree with it, but we do respect it. And despite your vote today, which is only a recommendation, we support this application and we will proudly continue to support the application. Thank you.
Thank you.
I guess I'll be the last one. Pat Young with the Operating Engineers Local 150. Local 150 supports this project. Thank you for everything you do. Thank you to staff. Good night.
Good night. Thank you, sir.
Mr. Chairman, oh.
Yeah.
Good evening, and thanks again. And I'm going to argue for the guy back here. I am the dumbest guy in the world. I'm a farmer. So y'all understand, we do have a horse in the race. We have 100 acres that's optioned on the property. I heard a lot of things. One of the things I heard in the original testimony from Mr. Becker back a month ago was he threw a lot of things against the wall. Some of it isn't true. For instance, he said the United States Department of Ag, and I got to look at my notes here. It's in the 229th minute of the recorded testimony that the United States Department of Ag, Secretary Rollins has, and let me get this. He said that it appears that the great majority of this land is prime farmland, so we believe that the federal government has preempted this and therefore cannot therefore the application is incomplete. And what he went on to say was they put a moratorium on building solar panels on farm ground. That's just not true. Again, he was sworn in, and that's not the case. We kind of went down a rabbit hole tonight talking about zinc. Candidly, we flat on with drones. It's in our fertilizer. Whenever you think about the big picture, we talked about the big picture with the last couple of speakers, there's so much stuff we dump on this ground. You ought to be happy that it's not going to happen once it's converted to a solar field. If you really knew what's in that stuff, our chemical guys handle it with masks, with gloves, and some of that stuff we can't agree causes cancer. That stuff all trickles in the water. It's not going to be put on the solar ground. And then finally, we talked about property rights. We own the ground. These people, we ought to be able to do with it what we want. I understand y'all, Will County got a bit of a demotion. Nobody likes a demotion with the state law that was passed. But truth of the matter is, it helps us do what we want with the ground we bought and paid for. Things are tough on the farm right now, and hopefully the county board will keep that in consideration. And I guess finally, the analogy I kind of draw is, hey, some of you guys are old enough to remember whenever the speed limit went from 65 to 55 during the oil embargo crisis. It's the law. We had to follow it. There's a bunch of laws I know I don't like out there. I understand there's laws out there that you don't like. I just would hope that the Will County government would understand we got to follow the law. We spent a lot of money on court cases, private. They hired additional attorneys and stuff. I think we'd all shake our heads about how much money was spent. The court's ruled. It kind of is what it is, at least for now. Again, I appreciate your time. You guys go through a lot. The final point I would make is you've heard from this sector, the people it affects directly. This is an area that's not dense, population dense as Will County goes. And so it is a better place than some of the areas to the north. You've heard from the other municipalities and the problems they have with community solar next to there. Again, I appreciate your time. Thank you for your attention.
Thank you.
Ray Nugent, Wilton Township Highway Commissioner. I'm glad that John is back to hear this. But surety bonds, and this isn't a slap at Earthrise, surety bonds are useless. If anybody's worked on a project that involves surety bonds, you've just made the job that much harder. Thank you.
Thank you, sir. Thanks, everybody, for the comments. We're going to now call for adjournment. Our next meeting is scheduled for the May 19th. May I have a motion to adjourn?
Make that motion.
Second.
Motion in a second? Do I have a
Yes, yeah, I do both.
Are you going to vote to close the meeting?
I didn't catch it.
Are you voting or are you all in agreement to close?
Yeah, we.
You have the motion, the second.
I have it. Okay,
But
all right.
we'll just wave our hands.
Yeah.
All in favor, signify by saying aye. Any opposed, same sign. Okay, thank you.
Hey, sir, we stay here long enough, we'll be